Good afternoon, ladies and gentlemen, dear President of the International Tribunal for the Law of the Sea. It's my pleasure to welcome you all to the Bucerius Law School of Hamburg for the opening of the 4th Hamburg International Environmental Law Conference. Let me go back a bit. I step back in history to tell you where this series of conferences comes from. In 2011, Hamburg was a European green capital, and on that occasion, politicians and representatives of law firms formed a society to support, at that time, one conference that turned into a series of conferences with the object and purpose to promote an exchange within academia, but particularly beyond, with practice, with decision makers, to elaborate upon improved environmental standards. So in 2011, we were able to welcome about 200 participants on a broad range of topics. So by now we have tried for this year and for the last conference, we tried to find a common theme. In 2011, there were the tremendously and still important issue of climate change, of hazards by shipping, offshore wind energy, but also the contribution of cities to environmental law standards. In 2013, because that first conference was so successful and the society was willing and able to take this endeavor to the future, in 2013, there was a second conference, again with issues on climate change and national and regional climate protection, but also already more marine environmental protection and world nutrition. And you will find that this year, again, we will talk about responsibilities for resource management, and Till Markus will give a presentation on EU perspectives on fisheries. In 2016, we tried to find a broad common theme at that time, sustainability, where we discussed different issues like deep seabed resources, again, also generation of energy from the ocean from the perspective of maritime governance and sustainability. Today and tomorrow, I should say, we will talk about responsibility, and again in a broad sense. So those of you who are trained in public international law at the university will say, oh, state responsibility, that only comes into play if you breach an obligation of international law. That's a too narrow focus. That's not what we will be discussing. It's a kind of a moral responsibility, but that also turns into legal standards of how actors should or must behave to meet a certain aim, in this case, marine environmental protection. But this is why you will find a focus on ports as important actors, but also, of course, because in the free and Hanseatic city of Hamburg, we have the second largest port in Europe with this close competition with Rotterdam, who is the leading European port. I'm particularly happy that we were, again, for the first time, able to assemble our very distinguished speakers and guests, that we were able, with this program, to attract more than 100 participants from all different areas of society. So not only from academia, but practitioners, decision makers, from public authorities, from law firms. And I think this mixture will give us very fruitful discussions. So I thank you for coming. I thank you for giving us your time, for sharing your expertise, for sharing your curiosity with us. Your questions to the speakers will make this, I hope, a successful event. I think together we will make this conference, I hope, and I'm sure, as successful as the other three events before. Needless to say that we needed partners and sponsors, and I'm not even attempting to memorize them all. You will see them up on the screen. It's impossible to organize a conference like this without our support. So our support by the city of Hamburg, that is something a very reliable source of support we depend upon, but of course also, since we are in this beautiful room, the Bucerius Law School and the University of Hamburg, who catered for this organizational stuff and these nice surroundings. Let me also say that I'm thankful for the members of the society behind this conference who gave the scientific steering committee all the freedom we wanted. That's always it's a wonderful position to be in. If someone else is guaranteeing that you get the funding and you are left to say, well, do whatever kind of program you want. That's a wonderful situation. You rarely have that. So I'm particularly thankful for those members of the society who nudged potential sponsors into making a contribution and for giving us this freedom to draft a program and to invite the speakers that we were able to get to Hamburg. So without further ado, thank you all very much for coming, and now it's my privilege and pleasure to give the floor to His Excellency President Jin-Hyun Park, the President of the International Tribunal for the Law of the Sea. Thank you very much.
Distinguished participants and ladies and gentlemen, herzlich willkommen to the 4th Hamburg International Environmental Law Conference. First of all, as one of the residents of this great city, I want to welcome all of you to the free and Hanseatic city of Hamburg. I also want to congratulate the organizers of the conference for putting together an excellent program that will allow us to discuss and reflect on the theme of responsible maritime governance for today and tomorrow. I was asked by the organizer to make an address of welcome for 15 minutes. I find the 15 minutes a little long to just welcome you, although I must say I most sincerely welcome you to this conference. Allow me, therefore, to take this opportunity to say a few words about the contribution made by my tribunal in the field of international environmental law. As you know, the International Tribunal for the Law of the Sea was established here in Hamburg in 1996 in accordance with Annex 6 to the United Nations Convention on the Law of the Sea. The principal task of the tribunal is to settle disputes concerning the interpretation or application of the convention. The tribunal and its seabed dispute chamber also give an advisory opinion. Over the past 20 years, the tribunal has dealt with 25 cases, both contentious and advisory, including one to which it will give its judgment next week. The subject of those cases were wide-ranging, but the protection of the marine environment has been one of the most recurring subjects the tribunal had to address. At least 5 cases were entirely or partly concerned with international environmental law. They include Southern Bluefin Tuna case in 1999, Mox plant case in 2001, land reclamation case in 2003, responsibilities and obligation of states with respect to activities in the area in 2011, and request for advisory opinions submitted by Sub-Regional Fishery Commission in 2015. This was not totally unexpected, but nonetheless was a surprising, I must say, pleasantly surprising development. It was not totally unexpected if you consider the prominence environmental issues have gained in international relations in the past few decades in general, and the importance attached to the protection and preservation of the marine environment in the Law of Sea Conference in particular. On the other hand, it was a pleasant surprise if you consider the fact that before 1990s, few environmental disputes had ever been submitted to interstate adjudication. Bering Sea fur seals arbitration in 1893, Trail Smelter case in 1938, and Lake Lanu case in 1959 may be more or less all we can count. Despite growing concern about the state of global environment and frequent rhetoric on the importance of its protection, doubts had lingered about the existence of general or customary international law of environment, as well as the utility of interstate adjudication to resolve environmental disputes. However, this prevailing skepticism, if I may say so, toward international environmental law and international environmental litigation has started to dissipate in the 1990s, especially with my tribunal taking a lead in opening a new chapter for international environmental adjudication and clarifying and developing international environmental law. Distinguished participants and ladies and gentlemen, now let me address briefly the environmental jurisprudence of my tribunal and its contribution to the development of international environmental law. You may know that the Law of Sea Convention is considered one of the most comprehensive environmental treaties, attaching special importance to the protection and preservation of the marine environment. However, the Convention, despite some mechanisms allowing for flexibility, is essentially a product of the law and realities of 1970s. The challenge facing the tribunal is, therefore, how to make the Convention relevant in an area in which law and realities change fast and will continue to do so in the future. I think that the tribunal has responded to this challenge quite well by interpreting and applying various provisions of the Convention related to marine environment in accordance with the evolving state of international environmental law. Let me make a few points in this respect. First, the tribunal has taken a rather broad view of the scope of marine environment, as well as that of obligation of states to protect the marine environment. According to the tribunal, the protection and preservation of the marine environment is not confined to Part 12 of the Convention. In this vein, tribunal found that the conservation of living resources of the sea is an element in the protection and preservation of the marine environment. The tribunal also noted that Article 192 of the Convention imposes on all states parties an obligation to protect and preserve the marine environment, and this provision applies to all maritime areas. Second, the tribunal emphasized the duty of cooperation in the protection of the marine environment. In a well-known passage in Mox Plant and land reclamation cases, the tribunal stated that the duty to cooperate is a fundamental principle in the prevention of pollution of the marine environment under Part 12 of the Convention and general international law. This finding of the tribunal needs to be appreciated, particularly in the light of the fact that the duty of cooperation is not clearly set out in the Convention. Thus, it is significant that tribunal referred to the duty of cooperation not only under the Convention, but under general international law. Thereby, the tribunal recognized the customary legal status of this duty, enabling the tribunal to invoke it in interpreting the relevant provision of the Convention. Third, the tribunal has demonstrated a proactive attitude in acknowledging the precautionary approach, perhaps more than any other courts and tribunals. While the precautionary approach had been pleaded in several cases before international courts and the tribunal, the tribunal's ruling in Southern Bluefin Tuna was the first to apply the core element of this approach. Without employing the term precautionary approach, the tribunal in this case prescribed the requested provisional measures using reasoning and an expression which closely resembled the precautionary approach. In the subsequent advisory opinion on responsibilities and obligations of states with respect to activities in the area, the seabed dispute chamber of the tribunal took a few steps further to clarify the legal status of precautionary approach. The chamber came close to acknowledging the customary legal status of the precautionary approach when it stated that, this is quotation, the precautionary approach has been incorporated into a growing number of international treaties and other instruments, many of which reflect the formulation of Principle 15 of the Rio Declaration. In the view of the Chamber, this has initiated a trend towards making this approach part of customary international law. Fourth, the tribunal clarified the obligation to conduct environmental impact assessments. In the above advisory opinion, the Chamber noted that the obligation to conduct environmental impact assessment is a direct obligation under Article 206 of the Convention. Then the Chamber went on to state it is a general obligation under customary international law. These findings and other relevant rulings of the tribunal and its chamber demonstrate their willingness to be proactive in preserving and protecting the marine environment. In so doing, I think that the tribunal has emerged as an important voice to safeguard the marine environment and promote ocean sustainability for states parties to the convention, as well as the international community as a whole. Distinguished participants and ladies and gentlemen, in closing, I want to remind you that the theme of the conference, Responsible Maritime Governance, which emphasizes the responsibility of states, is an issue my tribunal and its seabed dispute chamber had to examine closely in their two landmark advisory opinions. As you know, most maritime activities are conducted by private actors, be they natural or juridical persons. On the other hand, the Law of Sea Convention and most international treaties as well, for this matter, imposes various obligations, including those to protect and preserve the marine environment, upon states. Those obligations of states encompass not only direct obligations, but also so-called obligations to insure. The second type of obligations matters, especially with respect to activities carried out by private actors. In this regard, a question may arise as to what are the nature, content, and scope of such obligations. In fact, this question was at the heart of the request for an advisory opinion submitted to Seabed Dispute Chamber in the context of the obligations of sponsoring states with respect to activities carried out by contractors in the area beyond national jurisdiction. and then to the tribunal itself in the context of the obligations of the flag state with respect to illegal, unreported, and unregulated fishing conducted by its fishing vessels. In response to this question, the tribunal and its chamber elaborated the obligation of due diligence applicable to states in this regard. According to the chamber, it is an obligation, this due diligence obligation is an obligation which entails not only the adoption of appropriate rules and measures, but also a certain level of vigilance in their enforcement and the exercise of administrative control applicable to public and private operators, such as monitoring of activities undertaken by such operators to safeguard the rights of the other party. The chamber further stated, I quote, "The content of due diligence obligation may not easily be described in precise terms. It may change over time as measures considered sufficiently diligent at certain moment may become not diligent enough in light of new scientific or technological knowledge. It may also change in relation to the risk involved in the activity. The standard of due diligence has to be more severe for the riskier activities." By elaborating the obligation of due diligence, the tribunal and its chamber clarify the nature, content, and scope of the obligations of states with respect to certain maritime activities conducted by private actors. This finding may also be relevant to activities of private actors that may cause damage to the marine environment. We will be waiting for you to bring any dispute in this regard or any other dispute related to the protection and preservation of the marine environment. I will welcome you again then. Thank you very much for your attention. Vielen Dank.
Very much, President Pike, for your extensive welcome address. We very much appreciate that, that you shared your ideas on the important role of the contribution of the tribunal for the development of the law of the sea, and not just saying welcome. It's my pleasure now to introduce our keynote speaker, Professor Eric Franks from the Free University of Brussels. He is a full-time research professor in Brussels. But as I indicated in my words of greeting, since we are always trying to bridge between academia and practice, he's not only a full-time research professor, but also a practitioner. He is listed as arbitrator under the Law of the Sea Convention. He was legal counsel for the Netherlands in the Arctic Sunrise arbitration, and he's also a maritime boundary expert for the International Hydrographic Organization. So again, not someone who's just sitting in his room and thinking, but knows the practice. He will talk today about responsible maritime governance and the example of the Arctic Ocean spaces beyond national jurisdiction. And Eric, we're looking forward to your presentation. The floor is yours.
All right. Good afternoon. Is it possible to have the screen on here?
I don't want to push, Annie, ich möchte jetzt nicht irgendwo draufdrücken. Dass wir das Bild von der Präsentation auch hier.
Oh, Okay.
Sorry.
Sorry.
The other one.
Okay, thank you very much for the kind introduction. And welcome also, ladies and gentlemen. It was a very great honor for me when I was asked to say something as a keynote speaker on this conference. And I was thinking, when I was thinking about the subject, I thought that about responsible maritime governance, maybe the Arctic might be a good example at present. And so when I submitted that topic, I immediately found out that it would be a very daring subject to take. And I was already a little bit scared from the beginning because I found out that, of course, one of the organizers of the scientific body just published an article on that topic in a renowned journal. So it's always very difficult to treat then a similar topic. But at the same time, it's not only a daring topic, but it's a dear topic to me. And that is because my own PhD was on navigational rights in the Arctic. I still believe it was yesterday, but unfortunately it was already 30 years ago. And that was a time, let me tell you, that nobody was interested in the Arctic because it was still the Soviet Union time, and nothing moved, nothing changed. And so it was thought to be a senseless topic. I don't have to tell you that today, of course, the Arctic has, from the back burner, it has really rocketed to the upfront of the international attention because of climate change. Some of my colleagues were not that lucky because I had a colleague who, we had a Center on Eastern European Law at the time, still at the university, my university, and he was doing his PhD on the Socialist Party of the DDR. And by the time he finished his PhD, the DDR no longer existed. So sometimes you can be lucky, sometimes you can not be lucky. So that is why I thought that maybe it's a good idea to go back to the Arctic and see how responsible governance there can be detected at present. So what I will try to do is, first of all, a little bit of explanation of the title because we have to make sure that we narrow it down sufficiently. Then we talk about what should be avoided, and next what should be aimed at. Finally, also the agreement, and that is the essence of my presentation today. It will be about fishing. After the explanation of the title, that will become clear to you. It's an agreement which has been recently concluded on how to treat fish in the central Arctic Ocean. And then a few concluding remarks. But let's start up with the explanation of the title. Now, when we think about spaces beyond national jurisdiction, this can be either two ways, right? It can be the bottom and the subsoil, and then we are talking about non-living resources, mineral resources, and then we are talking about part 11. Now, this is a very interesting topic. Certainly, when I visited the Hamburg Maritime Museum yesterday, you will find a nice map out there where you will see the Russian claim towards the Arctic. So it's very hot, it's very topical. Nevertheless, this is not what we will be discussing today, because on this aspect, I think the convention itself has been very forward-looking, because they have established a specific commission which will see that states act according to the provisions of the treaty, which are very, very technical in nature in that respect. So much uncertainty remains out there. The United States is not a party. How will they ever be able to determine their outer limits? Russia has already tried once, was not successful, has to do it a second time. So up till now, only Norway, I think, has fixed boundaries up there. But as I said, this is not what we will be discussing today. We'll be interested in the water areas subadjacent to the seabed, more specifically all the living resources with the exception of the sedentary species, because they are, according to the treaty, treated as a part of the continental shelf, and that more belongs to the previous section than to the living resources. Then it will be not part 11, but part 7 of the convention, the high seas, and how fisheries will be governed there. So that is a setting. So let's now try to find out what we mean by fisheries in the Arctic, because here regulations is no different than in any other part of the oceans. Some legal scholars in specific countries have tried to make the argument that you don't find Arctic as a term in the convention, so maybe the treaty was not about the Arctic. I think today there is general agreement that it's not so, that the treaty is applicable to the Arctic, and fisheries, certainly jurisdiction extends there as well as any other place, any other ocean in the world to 200 nautical miles, and all the rest is then high seas. Now, if that is the starting point, then the question is, where do we find the high seas in the Arctic? Why is the high seas a problem? Because the tragedy of the commons applies there. In 1967, we had Harding making that argument for cows on land. So if you put too much cows on a particular area of land, then you have there's an overpopulation, and the cows will have no food, so they will die away. So the same with fish in the oceans. So you should do something about it. So what the convention did was exactly establish these 200 nautical miles, take most of the commercial fisheries out of the high seas freedom. These are the areas in the Arctic. As you will see, there are not only one area, the Central Arctic Ocean, but you have other so-called holes. You have the banana hole at the bottom, which has been treated by NEAFEC, the Northeast Atlantic Fisheries Commission. You have the Barents Sea loophole, which has been treated by the Russian Norwegian Fisheries Commission. And then you also have, if you look up north, the Bering Sea donut hole, the so-called donut hole, which also caused problems. Because what is the problem? The problem is always when fishery starts to generate in those areas, there is nobody there, there is no regional fisheries management organization, and so there is very quickly overfishing with all the detrimental effects attached to it. Now, the most of these problems was solved either by the coastal states granting other states access to their own EEZs if they don't fish in the high seas in between. But we will take the upper part, the Bering Sea, as an example of how things can go wrong if you are not taking in a timely manner, the necessary kind of actions. So our today's conference will also only be on the Central Arctic Ocean, so the middle part around the North Pole. This has been described very carefully by the new agreement. As you can read there, I think the important words here are exercise fisheries jurisdiction, because it's not what is normally read in fisheries conventions, where it's under national jurisdiction, because there is this problem of Svalbard, where fisheries, the question is whether fisheries extends to the Norwegian competence in the EEZ or not, because it all relies on an old treaty when the EEZ was not yet applicable. So let's start by telling how it should not be done. And this is a good example is the donut example, which I showed you on the map. It's an area which is located totally between the United States and Russia. And even more so, if you look at the map, it's an area where, which really belongs most to the United States, almost exclusively. There's only a small part which also belongs to Russia. Belong in what sense? Well, the sense that the two countries at a particular moment in time agreed that an old treaty, the Treaty of Cession of 1867, so it's a very old treaty, that line specified there should be the line which both parties would respect once they would extend their fisheries jurisdiction to 200 nautical miles. Now, both parties did that in the 1970s, 1976 to be precise. The United States was the first one, and it took the Russians somewhat, or at that time the Soviet Union, somewhat by surprise, because they, at the end of the year, did exactly the same, because otherwise they would be probably having a very negative effect on their fisheries. So they acted likewise, and both legislations went into effect the 1st of April the next year, 1977, and what they did was, before that agreement entered into force, they concluded by an exchange of notes in the beginning of 1977, January, February, they accepted that this old boundary would be the division line where the 200 nautical miles would touch. Not the other areas, but at least where the 200 miles would touch, that would be respected as what belongs to the Russian or the Soviet Union and what belonged to the United States. And as you can see on the map, it means that most of the area would be appertaining to the United States, as far as fishing jurisdiction would be concerned. All right, this as a backgrounder. Now, in 1982, the problem is then that, of course, the EEZ became accepted by an international treaty, which, of course, had not yet entered into force. But nevertheless, the International Court of Justice would be very quick in deciding that it formed part of customary international law. It was namely before the treaty entered into force in 1994, that already in 1985, in the Libya-Malta case, that the court stated, even though it was a continental shelf case, it nevertheless, in an obiter dicta, the court stated that the EEZ formed part of customary international law, meaning that all countries would be able to rely on it. So this posed a problem because where do the countries then go fishing? So two possibilities: either you pay your way into the EEZ of a coastal state, or of course you remain on the high seas where it remains a freedom. And of course the second option is cheaper. So it means that China, Japan, Korea, and Poland all went for the resources out there. The 1982 Convention is very ill-equipped to treat with this problem. In a book that we published ourselves, Law of the Sea in a Nutshell, we labeled this as a missing chapter of the 1982 Convention, because at that time states were so much concerned with the EEZ, and 95% or a little bit less of all commercial fisheries was transferred from the high seas freedom to the coastal states. So that took quite a lot of energy, and they forgot about the 5% which was remaining on the high seas, so no specific rules were to be found in the convention. The only thing that you read with respect to stocks which are straddling, they will tell you that states shall seek to agree. I don't have to tell you that if you try to implement these words in practice, it's very difficult, because the shall is an obligation and the seek certainly is not an obligation, and the agree is something that you cannot be forced to do. So it's very difficult to rhyme these words in practice. Now, these figures tell it all. These figures tell it all because you will see that for a long time the two coastal states remained fishing for the Alaskan pollock, because that was the fish that was at that time very much overfished inside their own EEZs. In the beginning, the United States was not very much interested, but they learned very quickly that it was a very lucrative business. So in a couple of years' time, they were able to fish all the catch. So it meant that once they were able to fish all the catch in the EEZ, there is no reliquat, as they say in French. There is no surplus, meaning that they don't have to give anything to any other country anymore. So it meant that the other states not only could not be invited to join inside the EEZs, because simply there was already the maximum sustainable yield had been reached. And then you see that these states then went for the middle part, and very quickly the number of catches were increasing immensely, to the point in 1998 where you see that so much fish was caught that even the coastal states never caught in their own 200 nautical mile zones. Now, if you look at if you compare the areas, the central donut hole is only 8% of the whole Bering Sea. So it means that in this small part, quite a lot of fish was taken. And then the two last lines, I think, tell you all. By 1992, all the fish had disappeared, and so there was a total collapse of the fish stocks. All right, so clearly how it should not be done. What was the reaction? Well, first of all, the United States tried to do it their own way, because, as I told you, most of this zone was US zone, so the fishing industry very much pushed the government to take unilateral action. Say, simply keep out all the others, even from the part beyond 200 nautical miles. State Department had great difficulties with that, also the Defense Department, so this did not work. Then bilateral negotiations started with the Russians at the time, but also the Russians were pushing the Americans, well, if you don't want to do it alone, let's do it the two of us. And simply because the zone is totally surrounded by the two countries, let's simply keep everybody else out of the zone. The problem is it's high seas, and so you don't have this competence according to the treaty. And if all countries around the globe would start doing that, of course, it would be very detrimental to states like the United States and like the Soviet Union in the past, which were naval powers, which would also mean that you would have creeping jurisdiction, something that they did not like at all. So finally, they settled for the multilateral approach, meaning they got everybody around the table, but they only did so at the time that the collapse had already happened. There was interim moratorium on fisheries in the central Bering Sea area, 2 years, and then they were able in 1994 to conclude an agreement, and the agreement is still operational today, and it states that it will be a moratorium until there will be sufficient stock to allow a maximal sustainable yield, but I can tell you that up till present, this has not happened yet. So it means that since 1992, this stock is still not being fished. Now, what was the essence of the agreement? Because that's always what interests lawyers. How were they able to make sure that these countries would stop fishing? Because the problem these countries put forward was always the same. Why should we stop fishing in the central part if you, coastal states, you continue fishing in your EEZs for the same stock of fish? Now, the agreement is only about the central Bering Sea, so it apparently gives the coastal states full credit for being very successful in their negotiations, but it's a little bit more complicated because the treaty also has an annex. The treaty also has what is called a record of discussions, and if you look in the record of discussions at the very end, you will read that the two coastal states, they understand that the pollock fisheries is an ecosystem, not only in the Bering Sea, but especially the pollock is an ecosystem within itself, and you cannot simply give it to or make a distinction between the central Bering Sea on the one hand and the other EEZ areas of the countries involved. So in reality, it means that countries now stopped fishing, and also the coastal states agreed that they would not resume fishing unless the others were able to resume fishing. So this is the crux of the agreement, but it tells you how difficult it was finally to find a solution. If we now turn to what should be aimed at, and I think the President of the Tribunal has already mentioned the great contribution of his institution to the development of the law of the sea, it is the precautionary approach. But as we all know, this is not to be found in the Treaty of 1982. It's to be found in the 1995 agreement which supplemented the treaty. Special situation of the Central Arctic Ocean now is such that, of course, it's a rather large area. If you compare it to the Bering Sea donut hole, the Bering Sea donut hole is really insignificant because this CAO, the Central Arctic Ocean, it's more than the whole Bering Sea as such. So it means it's a very large area. But on the other hand, fishing has not occurred there yet for the simple reason that the area is covered with ice or has been covered with ice. So it's not because countries did not want to fish there, simply because they were not able to fish there. The problem now is with climate change, will this open up also to fisheries? Because my PhD was about navigation better, and navigation today has become a reality in the Arctic, where in the past it was something which was very hazardous. Now, what about fisheries? Will there ever be a day that the Central Arctic Ocean will be able to be fished? Well, this is a map of the area which shows you that in 2012, and the map is 2012, not because I didn't find a more recent one, but simply because 2012 has been the year that the ice has retreated most up till present, right? So in that most favorable scenario as of today, you will see that parts of the Central Arctic Ocean have become ice-free, so they can be fished in reality or in theory. But it's a little bit more complicated than that, because no commercial fisheries has taken place, And nobody knows exactly, because it's very difficult to do scientific research, because there's an ice cover, a very thick one sometimes, and so there is simply a lack of knowledge. Nobody knows whether there are discrete species in the Central Arctic Ocean, meaning species which are not moving between that zone and EEZs of the neighboring countries. And even though most of the countries are covered by a regional fisheries management organization, if you look at the map of FAO, it will show you that the Arctic is one of the rare exceptions, where today you don't have a regional fisheries management organization there. Now, saying that there is no regional fisheries management organization is not totally correct, because the NEAFEC, the organization I already mentioned, has 8% of that area covered. But if you combine that with the next picture, which shows you the, first of all, the areas less than 2,000 meters deep, which for fisheries are the most important areas of the oceans, you will see that unfortunately that area is to be found on the totally opposite side of the Central Arctic Ocean. And also the open waters surrounding it are found on the totally opposite side. So in reality, one can say that today there is no regional fisheries management organization which really has anything to say with fishing which might be going on. So what action should be undertaken? What countries did was they could, of course, take action in their own EEZs, which is already a very big step forward, because that's where the fish will arrive first before it will move into the Central Arctic Ocean. But the scientific community found that it didn't go fast enough. And in 2012, they convened not only of the 5 Arctic states, but also of other countries, and they put forward this idea that you should stop fishing unless you know that there is sufficient to have a maximum sustainable yield. So it should be on a scientific basis that you start commercial fisheries out there. The Arctic 5, meaning the Arctic countries having a coastline in the area, being Canada, Denmark, Norway, Russian Federation, and the United States, they thought that they had the power to regulate this element. Well, at least the United States found that they should start international negotiations in 2007, but then 1 year later you had the Ilulissat Declaration, where these 5 states stated that, well, we don't need a new international regime, we have it, and we have it meant in the first place the Law of the Sea Convention, but at the same time this declaration, they stated that the Arctic 5 would be the claim stewardship, as they nicely call it, so they would show the way how to do it. But if you then look at the same declaration and try to find anything about fisheries, it's a very, there's not much to read, because there is something about resources, but mostly the resources were about the non-living resources. So then in 2015, finally they arrived at what is called a joint declaration in Oslo. And this was for the first time that the 5 Arctic countries together agreed what the scientific community had suggested in 2012 to a large extent, namely that there would be no fishing unless there would be a regional fisheries management organization which had given its approval. So it meant that there would be no unregulated fishing, at least not for commercial purposes. The interim measures were also not only the vessels should not fish, but at the same time it was also very well realized that they needed more scientific research. So like in the Antarctic Whaling Convention, there was a provision trying to stimulate the countries to establish joint scientific research with respect to fish, and then also, as you can see, other preventive measures with respect to make sure that others would respect this kind of non-commercial fisheries. But of course, I don't have to tell you, this is a non-legally binding document, so they did not have much room to maneuver other states or to twist hands of other states to make sure that they would accept. Now, I would say that the biggest problem with this declaration of Oslo was that it was the 5, and only the 5, because you know that we have something which is called the Arctic Council, and that's the Arctic 8. So besides the Arctic countries that are listed, there's also Finland, Sweden, and Iceland. Now, it only took 1 month after the Declaration of Oslo in 2015 for the Iceland Ministry of Foreign Affairs to convene a meeting with all diplomats of the 5 Arctic countries to tell them that they did not like the Oslo Declaration. They found it a non-legally binding document, which is true. Everybody finds that, but they also said that they were not bound by it. They wanted to put it on paper, or at least make it clear to the countries who made the declaration. And at the same time, they also said that they should be included because they have so much knowledge about fisheries in ice waters. And their country was the first one where all these northern movement of fish was to be found. So this is then the second part, and that means that the 5 then went to broaden a little bit the number of countries which would be involved. It was not only Iceland which was very much against, also the EU tried to have other fora to move forward, and even China, I don't have to tell you, is also very much interested in the area. So all these countries were not very fond of this Oslo Declaration and the way in which the 5 Arctic Rim countries had moved forward. So what they did was then join together and try to establish something new. And it was then the 2018 agreement at the end of last year. We now have an international legally binding document. It's not yet enforced, but it just has been signed. Now, the Oslo Declaration clearly stated that they were able or willing at least to expand the membership, but that the membership should respect what the 5 had done with their Oslo Declaration. So it's very interesting to see how the one document compares to the other. And here we see what remains certainly is that the 4 interim measures are still largely in place. And what then is new? New is that, first of all, the legally binding document, which the Oslo Declaration was not. Now we have an international treaty, and it already looks into the next step. That is, what if commercial fisheries becomes possible, if the maximum sustainable yields allows for the fisheries to take place, then the agreement already previsages that a regional fisheries management organization will be established. The relationship between the A5 and the A5 plus 5 is a very interesting one to see, because in the beginning, of course, the A5 tried to be the prime movers, or the ones which have prime responsibility. Now, if you read the treaty, you only find a reference to that in the preamble. All the rest parties are on a foot of equality, meaning that the voting, also the entry into force, you need all the countries before this new agreement will ever enter into force, meaning that everybody has the same stature. Dispute settlement provisions is also very interesting to note, because if you look at the practice of states, very often you have, because the 1982 Convention is a very progressive document with respect to dispute settlement. It's very extensive. More than 100 articles of this treaty, which counts 300 and a little bit, is about dispute settlement. Now, instead of reinventing the wheels, what many conventions do is they simply refer back to the Part 15 of the 1982 treaty. Now, if it concerns fisheries, many of these other fisheries, regional fisheries management organizations, when they are created by treaty, the treaty not only refers back to the 1982 agreement, Part 15, but also to the part of the Treaty of 1995, the United Nations Fisheries Convention, because it is specifically about fisheries, and there are some accommodating articles on how to insert the 1995 fisheries agreement into the dispute settlement, into that of Part 15 of 1982. But here, and this is the first time that it happens, since we do not know whether there are discrete fisheries in the Central Arctic Ocean, they also refer back only to the 1995 agreement. Now, this 1995 agreement only concerns 2 species, which has nothing to do with discrete species. So it might have been, I would say, a little bit of the precautionary approach for the parties, if at least they would have referred back to the 2 treaties instead of only the 1995 one, because they might be missing out something. the reason why might have been that, of course, not all parties are, or not all the 5 Arctic states are also party to the 2 treaties in question. If you look at the LOSC, the Law of the Sea Convention, the United States is not a treaty. If we look at the 1995 agreement, China is not a treaty party. So it might have been that a choice had to be made on that respect, but as I said, it would have been more prudent to include both of them. And this brings me to my conclusions. So if we compare how fisheries has been treated in the Central Arctic with how it has been treated elsewhere, I think this is very positive as far as the international community and responsible management is concerned, because as stated by one of the privileged observers, this will be the only, and I quote, this will be the only ocean in the world that humankind have agreed to not fish in until we have a scientific understanding of what's there and the management regime under which to operate. Up till now, it always worked the other way around. We fished on the high seas until it was depleted, and then it's sufficient to look at the FAO statistics to notice that, and then international action is taken. But, of course, there are also some minor points I think we have to take into consideration. Difficulties remain. What is the appropriate body? I have tried to explain you that the Arctic Council has been put forward, the NEAFEC has stated, and their first reaction to the treaty when it was adopted in last year, at the end of last year, was they issued a declaration saying, we have noticed that this agreement has been concluded, but we, NEAFEC, we are competent with respect to fisheries in these 8% of the area, and they stand, they put their claim, I think, very clearly. Also, the United Nations General Assembly at a particular moment in time has been put forward as a possible forum, like at a particular moment in time they also did with the Antarctic, remember. And then the Arctic 5 came in 2015, and then the Arctic 5+5 now finally ended up with the agreement. Is that now the end of the line? Well, the whole question is, maybe there are other countries out there who do have an interest in fishing when fishing becomes available. Because the whole problem is that, of course, today we don't know who is interested in fishing there because no fishing has been going on. Meaning that you cannot go on historic catches to show your interest in the area. So the 2018 agreement is also only an intermediate step. The preamble at present says that it's premature to try to establish an organization, but it might become relevant. And then the question is who to invite. And here the new convention states that if all the Arctic 10 agree, they can invite others, if they have a real interest. All right? But how to make sure that there is a real interest? Of course, the 5 hold the key, because they will have first to invite them. And as I said, I didn't say that, but all decisions which are not procedural have to be taken by consensus. And everybody can raise or can state simply that they think that something is more than procedural. And if it's sufficient that one country says so, and then everything needs to be done by consensus. So again, it gives everybody in reality a veto power if they don't like to invite a particular country. And then the last thing I would like to say is, after a long period of having too few international treaties in the Arctic, when I wrote my PhD, there was only one treaty which bound the 5 Arctic countries, and that was a treaty on polar bears. And remember, the polar bear is now threatened with extinction, so maybe this meant that at a particular moment in time there was no single treaty binding the 5 Arctic states. Now, today this has changed in the framework of the Arctic Council, international under its auspices. Other conventions have been signed and already entered into force, but the question is, why is it possible, or how is it possible that if scientific research is so important in this 2018 agreement, why is there no reference to the treaty which has just been concluded on scientific research? And this is a very pertinent question, I think, because this treaty just was signed in 2017, entered into force very recently, and the 5 Arctic countries very well knew about it because they are all involved in concluding this treaty. And now, The last slide that I would like to show you is, we all know that the Arctic does not have one single definition, right? But nobody knew that such a definition of the Arctic would be possible. So it's a very complex definition of the Arctic, how to describe it, but nevertheless, and it says even underneath, it's a part of that treaty, an integral part, but it says that the lines may not represent very exactly where the outer boundary is. But for us important is that if you look at it, you will see that the Central Arctic Ocean is totally covered, right? So scientific research and the increase in scientific research between these countries normally should go through this agreement, and nevertheless, the fishing agreement, which is so much needs cooperated action with respect to scientific research, doesn't say anything about it. So how can you move in different levels at different times periods? So with this, I would like to leave it, and thank you for your attention.
Setting the scene so perfectly, for taking us far away from Hamburg to the Arctic Ocean. And you will see then today and tomorrow we will always move back and forth from ports and issues that concern Hamburg to areas far off. There's no discussion foreseen for the keynote speech, but since we're so perfectly in time, I want to change that. I would like to allow for one or two quick questions if they're so urgent, if you would like to share them with the auditorium. Short questions? Alexander.
I'm going to speak loud. Thank you so much, Eric. Fantastic talk. And I'm going to keep you away from the copyright. That's the main purpose of my question, of course. I was wondering, when you spoke about the potential institutions concerning fisheries, there has been a discussion of whether the Central Arctic Fisheries Agreement is not a regional fisheries management agreement itself in terms of, thank you, in terms of the 1995 agreement. So I'd be curious to learn about your position, because obviously, as you stated yourself, the moratorium is not a complete one, it is an interim moratorium, so the agreement may well become the legal basis for fishing activities in the Arctic Ocean. So I wonder, do we really need something else, or isn't just that very agreement enough in terms of cooperation under the 1995 implementation agreement? Thanks very much.
Thank you very much for the very interesting question. On the one hand, I would say that the agreement itself, like you yourself stated, it's not really a moratorium, right? So it means that the only thing that they do is that they say that they will not fish unless there is, it is clear that there is sufficient fish to, on a scientific basis, to allow for commercial fisheries. Now, this, I think, depends on whether you have a regional fisheries management organization which is capable to tell you whether there is sufficient fish in the area. And so I told you about NEAFEC, which already reacted to this adoption of the treaty. I think NEAFEC very well put forward the claim that if in their area fisheries will become possible, they will be the one who will be determining whether there is a possibility to fish or not. And it's very clear that if you look at the way the convention has been drafted, or the agreement has been drafted, that this has been very carefully managed, right? Because they say that they do not interfere with whatever NEAFEC will be dealing with. And NEAFEC, in response to that, reacted saying, yes, since this agreement very clearly states that they don't take away any of our competences, we are the ones who are competent if ever it becomes that way. But as I try to move or to prove by showing you the different maps, probably NEAFEC will not be the first regional fisheries management organization where this will happen, right? So it will be under the aegis of some other organization. And there is no other organization for the moment, so I think personally that if fishing becomes possible, it will be in the southern, well, what you call southern, if you look at from the pole, there is no south, no north, but it means that the area in front of the US coast and the Russian coast, if that becomes possible outside of the 200 nautical mile zones, I think there is no regional fisheries management organization, and only commercial fisheries will be possible if by that time the interim measures are lifted by the creation of such an organization. And I hope this responds to your question.
Thank you very much. One very last brief question, and then it's a coffee break.
Thank you very much for this fruitful lecture on sea laws. But a practical problem which I felt, that is the problem between the states regarding the fishermen who visit the sea for the fishes, and the other country caught the persons. Either there is a specific law regarding the information of that people, that till how long nautical miles these person can go in the sea. And secondly, some people, most of them are not known to the sea laws clearly. Secondly, is there any boundary of every country where it is warning for the people who are fishing in the sea areas, that they will know earlier that we shall not go beyond that limits? So regarding this matter, either any law is well established for the knowledge of the persons who are not well educated, but they will be properly warning and informed in these manners.
Okay. Thank you very much. I take your question not so much specific to the Arctic, but more generally in fishing law, because to my understanding, before you move into the Arctic to fish, you will very well know what the legal regime is there, because you will not go there by a small fishing boat. You will need probably a very strong vessel to be able to cope with that. So it means a lot of investment, and when you invest, you probably also take in legal advice on what you can do and what you cannot do. But you know, the problem that you raise is that, of course, if you have small fishing vessels and you are in an area of a boundary, and differently from land, of course, you don't fix any boundary at sea, so you don't see where the boundary is, and especially the fish certainly doesn't consider the boundaries created by men. So very often what we see there is that both sides, or if the relations are rather good, both sides take into account some kind of a safety zone, I would say, from the limit at sea, to make sure that fishermen, either they are warned and then they go back to their own position. But sometimes, and this struck me when I was doing the research for this paper, sometimes it's not of bad will. Because in this old agreement, based on the 1867 Treaty of Cession between Russia and the United States, so it's a very old treaty. They created a line on a map, but when the people said, we will use this line to separate our fishing competences, one of the captains was captured by the Russians. He thought that he was still in the American zone, but the Russians thought that he was in the Russian zone. And this was not of bad will. It was not that he wanted to go into the Russian zone to fish and then escape. No, it was simply because the way in which you determine on a map a straight line can have different kind of connotations. So sometimes it's not even because people do not know where they are. It's simply because there is not a unified way of looking at things. So it took the Americans and then the Russians a new treaty before they finally settled that one.
Thank you very much. I think now we've successfully reduced your coffee break. I wish you all a nice coffee break, and thank you so much again, Eric.
Thank you for the invitation.
Ladies and gentlemen, I may welcome you back after coffee break. Thank you very much for being so on time. We are looking very much forward to exciting panel this afternoon. Our president and our keynote speaker, I think, have perfectly set the stage for the overarching responsibility topic. And now we will come to some more specific aspects of responsibility. And on the first panel, we will discuss green harbors and port state responsibility. And I'm very glad that we have 3 distinguished speakers. However, our first speaker, most unfortunately, is so distinguished that many people want to have him. And therefore, he needs to rush. You know, he will present his speech. Then we will have a brief chance for questions and answers. And he then will leave. And after he left, I will introduce the 2 further panelists, and we will have a bit more relaxed discussion then. But I ask for your kind understanding that we take care of these time constraints, and we are all the more happy that you took your time, even though you're so busy, you know, traveling back, I think, to Brussels at 7. And therefore, without any further ado, I'd like to introduce Professor Van Hooydonk. He is since 2010 Port Law Professor at Ghent University, so the expert in the field that we are discussing there at the Department of European, Public and International Law. He, of course, is specialized in maritime law and in international and EU seaport law, one of the really most distinguished experts in that field. And who else could deliver a speech on our first topic, if not you? If I now would mention all the other achievements you made, unfortunately, you would be on the airplane already, and therefore the floor is all yours. Thank you very much. Looking forward to your presentation.
Thanks a lot for the very kind words. And first of all, I would like to thank the organizers for inviting me to this very interesting conference. And in this most fantastic port city, and I don't say this to be kind or to flatter you, because I have hard facts to prove this. Because back in 2007, I wrote a travel guide about the 3 biggest port cities in Europe, Antwerp, Hamburg, and Rotterdam. So I spent a lot of time here, and I brought 1 copy of it for Professor Preuls as a present. The only thing, it's from 2007, so I cannot guarantee that all the recommendations on the facilities of the Reeperbahn are still okay, but you will have to check for yourself, I think. It's a special day also for another reason to me, because at this very moment, as we speak, the Belgian Parliament is supposed to be voting on the new Belgian shipping code. This is a project that I started 12 years ago, so it took a serious part of my life. And we worked with the Commission for the government on this draft. Erik Franks was also a member of our commission. So, and normally today this shipping code will be voted in the parliament. So Erik, I will let you know this evening what happens. So I have a presentation, ladies and gentlemen, on the green aspects of ports. This is, of course, an extremely broad topic. And for that reason, I made a bit of a selection. And you all know that ports and the environment are a very difficult marriage. Also, the public image of the shipping sector and of the port sector among the general public is not always that nice. The general public and the media are interested when there is a calamity, an environmental disaster. And I have brought you also some pictures about what is happening in my own port city, Antwerp. And I have to correct one thing here. Maybe not so kind to Hamburg. It is Antwerp that is the 2nd biggest port in Europe, not Hamburg. And this is the case both in terms of total traffic volume, but also in terms of containers. And 10 years ago it was different. And then it was Rotterdam, Hamburg, Antwerp. And for several reasons, also due to environmental law issues, it's now different. Antwerp is the 2nd one and Hamburg is the 3rd one. And I know in Hamburg you had this problem of the deepening of the river Elbe, There were a lot of environmental law issues there, and also recently new problems in relation to public procurement, the designation of the dredging company. But also in Antwerp, we have big issues relating to environmental law. And this is some kind of logo that is used by a campaign group, local residents who campaign against every new attempt at developing the port of Antwerp. And I don't have to translate this for German people. Stop the waanzin, stop the madness in English. And it's written in blood, as you can see. I'll try to find my pointer. Yes, it's in blood. And this is the big ship that is devouring a little village with a church tower, a windmill, and a medieval shipwreck that was found at the very site where the container port is supposed to be developed further. This is a very interesting thing because also some kind of German ship. It's a Kogge, as you call it, a Kog vessel. So it's a very important shipwreck from a heritage perspective. But you see the image that these campaigners paint of the port. It destroys everything that is nice and beautiful. So what I'm not going to do is to provide you with an overview that would be very boring of all the relevant environmental rules that affect port operations and port management. There will be very interesting speeches also when I go, and I'm very unhappy that I will have to miss these. But I selected two topics to discuss a bit further. And the first one is the impact of the European Bird and Habitat directives on port management and port development. And the second one is the environmental rules contained in the brand new European Seaports Regulation, which is a piece of EU legislation dealing with port management, and it contains several provisions dealing specifically with environmental matters. So the first of my two chapters is about the European Bird and Habitat directives. And we are talking here about something of huge importance. What you see here is the main container dock in Antwerp. It's called the Deurgang dock. And you see all the yellow boxes. It's the home terminal of the ship owner MSC, the yellow containers. Their main European hub is here in Antwerp, and this is today the biggest container terminal in Europe. And we have, I think, some 4 or 5 container terminals in Antwerp, but this is the biggest one. And it's a very nice one. It's very impressive to see, but there is one problem with this container terminal. As you can see on the photo, it is full. There is no space left. And the port is struggling to find an expansion. So this is really about the future of the port of Antwerp as the second port in Europe. The logical solution would be to create a new dock. The photo you saw on the previous slides was this dock. This was before the terminal was in operation. This is the site of this big terminal. And the idea for, already you will find such a photo in my travel guide in 2007. So, because this was already then the plan. It was already considered urgent at that time, more than 10 years ago, to create a new dock, an even bigger one, which would be located here. But here I have to explain a bit what the problem is in terms of environmental law. Maybe I'll take a step here to show you. So the photo of the container terminal was this dock. And this is part of the left bank of the river. So this is the river that comes from the sea, the Scheldt River. And the city of Antwerp is here. And first the port developed on the right bank until it reached the border with Holland. So it could not be extended any further. So the port had to move to the other side of the river. And for that reason, back in the 70s, this area here to the Dutch border was reserved for future development of the port. So from a policy point of view, a very wise thing to do, to reserve an area for future development. But because of this, these docks were then constructed as from around 1970, but then we had an economic crisis, and also we had problems in finding a connection over Dutch territory for a ship canal. The original idea was to construct a big ship canal to the Scheldt this way, to allow deeper ships to enter that new port, but we had problems, as we always have, with our Dutch friends, so this didn't materialize. And for that reason, this area remained empty for a very long time. There were just docks, water areas, but no terminals, no factories, no new residential development, of course, because it was not allowed. It was reserved for future port development, so it was a wasteland. And the only creatures that were interested to go there were birds and animals and nice flowers. And in the 80s, then the Flemish government decided, on the advice of bird experts, to designate the same port development area as a bird zone under the European Birds Directive. And also several areas by the river side were designated as habitats, protected habitats, under the European Habitats Directives. Two important directives, European laws about nature conservation. So you see, we had here conflicting zoning, a port development area that at the same time got the legal status of a nature conservation area. And this is a problem that was created back in the 80s. No one at that time was aware. The Port Authority was not aware of what was going on. No one had any idea of the potential impact of this designation as a nature zone. But now we are still today, 2019, struggling with this problem. And we are trying to find a way to keep the ports flourishing and growing. And we are talking here again about the future of the second biggest seaport in Europe. So this is again the existing dock and the intended new dock, bigger than the existing one. And this dock would be located, its mouth would be located here, right where there is a small village. It looks nice on the photo, but in fact, to be objective, it's not that special, such a special village. And it was then compulsorily acquired by the public authorities with a view to the construction of the dock. And today, only I think some 5 or 6 or maybe maximum 7 people live in that village. All the other houses are derelict, are empty. So this is some kind of ghost village today. And it's only some hardliners that continue to oppose the port development project that continue to live there. There is not one shop, there is not a school, there is nothing. Only some 4 or 5 or 6 people living there in that ghost village. And the village is located right here, where the new dock is supposed to be connected to the river. So to come to the present situation, this image, you see this is the existing container dock with the existing container terminal. Here the intention was to construct a huge new dock, bigger than this one. And now the compromise, the political compromise that the Flemish government is working on, is to do something entirely different, to keep in place the uninhabited little village here, and to construct a very strange mini dock, destroying part of the existing container terminal, creating an entrance here, and here a very, very small mini dock with maybe 2 or 3 berths for ships. The pilots are very worried because this is a very difficult river. It's even more difficult than the Elbe. How to bring a 400-meter container vessel, we have almost 6 meters tidal difference twice a day, strong currents, to bring that ship like this into that little dock. There will only be container facilities here on one side, because the other side will be a buffer zone to protect the village and the surrounding countryside. So, and this is, the risk is for the port that this is the only development that will be allowed in this huge area, which I showed you on the map before. So maybe this is good news for Hamburg, but it's not good news for Antwerp, for sure. So what is the reason why I decided to go into this? Because a long time ago, in 2006, it was my last book before I started on the travel guide. In 2006, I made a study for the European Commission. Okay, and the study, thank you. The study was for DG Move, it was not for DG Environment, so it was for the transport policy makers in the European Commission in Brussels, and they wanted to have an overview and an analysis of the impact of the Birds and Habitats directives on port policy and on waterways policy. And this was published as a book. I think it's out of print now, but anyway, it was in 2006, and I reached a number of conclusions, and I identified problems at the European scale, not just in Belgium. There was an insufficient integration of policies. You had environmental policy and a policy department in the Commission doing its job, and next to it, somewhere else, you had people dealing with transport policy, and they didn't talk to one another. They were not interested in what the other party was doing. There was a total lack of integration. I also tried to make an inventory in my study of all the problem files and the court cases and the delays and the cancellations of port and waterway related projects. And at that time, it was really huge. It was a terrible mess, we could say, at that time in the entire port and waterway sector. And there were many, many unsolved problems, and the most important one was a total lack of legal certainty. The bird and habitat directives are written in a quite vague manner. It's about principles, very general principles, about nature protection and procedures, how to decide on a new project, and so on. But the outcome, when campaigners went to court, the outcome was totally unpredictable. And authorities tried to find their way, but it was a mess. It was total uncertainty, also for investors, not only for authorities. This is just a list of 10 causes célèbres, so the 10 main cases that also gave rise to court judgments, also in Luxembourg, from the European Court of Justice. Also some in Germany. And the list is even longer, so I try to analyze all these problems. And I came to the conclusion that, in fact, most of all the problem cases relating to the implementation of the Birds and Habitat directives related exactly to waterway and port projects, either new developments or even just maintenance dredging activities and things like that. I also noticed that the pre-existing status of ports and waterways was never taken into account when the nature directives were implemented. I showed you this zoning in Antwerp for future development, but there are other examples as well. For example, in relation to the river, our river access from Antwerp to the sea is the river Scheldt, which has its mouth in Holland, and the status and the freedom of navigation on that river is protected by fundamental treaties signed between Belgium and Holland. All this was never taken into account when it came to the implementation of the nature directives of Europe. So there was no integration between policies, and there was no integration, more specifically, with the trans-European networks policy of the European Union, which is the flag under which transport infrastructure is developed in Europe. What was also ignored was the inherent scarcity of port development areas. Of course, nature conservation areas are, by their very essence, scarce goods. No one will deny this. But also a potential port area is probably even scarcer, because a port must be located somewhere near a maritime access route, and also a port cannot be relocated. A bird can be relocated. For that purpose, it has wings. It can fly to another place. A quay wall or a container terminal cannot fly to another place. So the scarcity of a port area is even is even more urgent, so to say, or more extreme than a nature conservation area. But all this was ignored. There was this massive legal uncertainty. Court judgments, as I said before, were totally unpredictable. The directives, I should also point out, this is also the case with our problems in Antwerp today, these nature directives are very often used by people and groups who are not interested in nature conservation at all. They just use it, or rather their lawyers use it, or abuse it, one might say, to go to court and to make their point and to stop a project out of not in my backyard considerations, protecting very often their own private interests. And also in Antwerp, the authorities have been developing, in order to try to meet the requirements of the directives, to proactively develop artificial nature zones in that port area. But these projects are really hated by these campaigners. They are not interested in nature conservation, and they are even against it. But still, they use the legal weapon of the Birds and Habitat Directives to go to court and to stop the project. This is, of course, has never been the intention of the European legislator. The intention was to create a framework for nature conservation, which is, of course, a very legitimate thing to do and a very right and correct thing to do. But the instruments are used for other purposes. And also, finally, I came to the conclusion that there was and there is a very serious risk of distortion of competition between ports, especially because national authorities interpret and apply the European directives in different ways. And I also noticed this when I did the study, for example, in England. They give a different interpretation, which doesn't surprise us, of course, as far as the English are concerned. By the way, the reason why I have to run away is that tomorrow I will be speaking at an event in Antwerp about Brexit and the ports. So, okay. But I cannot make any prediction about that, I must say. So, what made me curious when I was invited to this conference is to know what happened after my study. What happened after 2006? And I am still working a bit on my paper. Hopefully you can still accept it for a publication. And I am still analyzing a little bit what has happened in the meantime. There have been a number of new court cases. I think 3 Luxembourg cases were also about ports. There was one infringement case against Ireland. There was one very important case from a legal perspective about the maintenance dredging in the river Ems, leading to the important shipyard in Papenburg in Germany. And there was another case which went totally wrong for Belgium and the Port of Antwerp in 2015, exactly about this port development project in Antwerp. The European Commission, after my study and also in consultation with the sector organizations and the environmental NGOs, issued guidelines to clarify the Birds and Habitats directives in 2011. But I must say this is a very general guideline, and it doesn't really, it's not really of concrete help when it comes to the main key legal interpretation problems. In terms of European transportation policy, a new regulation was adopted in 2013, creating a new framework for the development of the Trans-European Transport Network. It refers in many articles to compliance with environmental rules, but it doesn't really give a status, a specific status to port development areas. By the way, one of my recommendations, it was more a suggestion to open a debate in my study of 2006, was to create, next to the nature conservation areas, to create a legal status for future port development areas, for the reason that they are scarce goods. Like we did at national level in Antwerp, to create a protected zone for future port development areas. I raised this issue, and many people in the port sector liked this idea, others did not, especially the English again, they were against it because they don't like any rule coming from Brussels on whatever subject. So this didn't materialize, but in any event, today the new Trans-European Transport Network regulation doesn't really create any progress in solving these issues. And then finally, as you probably know, in 2016, the European Commission organized a so-called refit exercise, which is, in simple terms, an evaluation of the functioning of European legislation. And they did it in 2016 for the Birds and Habitats directives. And the environmental NGOs were, of course, very active in providing input. There were also some comments, some complaints sent to the European Commission in that context by waterway administrations and port authorities and ministries responsible for public works in member states, pointing out the lack of legal certainty created by the Birds and Habitats directives. But in the end, the European Commission decided that the Birds and Habitats directives are functioning perfectly well and that there is no reason whatsoever to consider any amendment of these directives. So as I am still working on my paper, I cannot give you my conclusions. I would rather call them at this stage impressions about the current situation. There has been made available some useful additional clarification by the European Court of Justice. There are, of course, very sincere efforts of many involved parties, public authorities and environmental NGOs and so on, to try to reconcile the legal frameworks and the objectives. But I think still this fitness check of the Birds and Habitats Directive was flawed because the environmental administrations and the environmental NGOs, they always use the same excuse. When things go wrong or there is a court case stopping a project, they always have this excuse, you didn't read it correctly, you have to read it better. You don't understand the Birds and Habitats Directive. It's your own fault that it went wrong. And this is always the excuse. Of course, this is totally wrong because the inherent problem, the cause, is the lack of clarity in the directives themselves. That's the problem. Because as I explained in Antwerp also, the Port of Antwerp really did its best, together with the Flemish government, to proactively create, before the container dock was even started, to create new nature zones, to try to avoid all problems. And everyone thought in Belgium that this was the right thing to do. And it was supported, albeit informally, by the European Commission, by the environmental officers of the European Commission. And still the court in Luxembourg, when these campaigners went to court, the court said, no, this is wrong because you were using a wrong paragraph in the Habitats Directive. So many people do their best, but it's so terribly difficult to do it in a legally robust way that will be supported by the courts. So in essence, the same problem of unpredictability is still there. For that reason, I am of the opinion that there is still a need for additional guidance on the interpretation. There is still this problem that people who are not interested in nature conservation at all try to abuse these directives. The risk of competitive distortions is still there, but also, and this is my final point, I think realistically we have to be aware that it is politically impossible to change the Birds and Habitats directives. We have seen this very clearly during the refit process of the European Commission. It is really a taboo subject. You cannot even, I know there were some European members of the European Parliament when I did my study. There were some guys that, yes, I consider taking an initiative in the European Parliament to make some changes to the directives. And after a while, after having thought about it, he said, no, I don't dare to do this. I cannot do this. It's impossible. It's a taboo subject. So, but this is the reality is, I show you the photos, the reality is the future of very important ports is at stake. I don't know how much time I have left. I have no time left. Yeah, I will be very brief then on the second chapter, because this is about the environmental aspects of the new European Seaports Regulation, which is a new piece of European law that regulates how port authorities should grant access to services markets in a port. For example, how a towage provider can get the authorization to offer its services in a given port. This market access. And the second thing, there are provisions about port dues, port infrastructure charges, as it is called in the regulation, and also port service charges. I have made an inventory in these slides, just of an informative nature, of all the relevant environment-related provisions in the regulation. I think I don't have to explain all this because I left some leaflets downstairs of a new book of more than 1,000 pages in which I try to explain all the details about this new regulation. So if you're really interested, I can recommend the book. And maybe it's now time to allow the chair to ask for a few questions. I thank you anyway for your kind attention.
Yeah, thank you very much for that wonderful presentation and that very thought-provoking speech. You get a little present. All the others found already the present in their hotel rooms, all the other speakers. But since there is no hotel room for you, we do it that way. I welcome some very few questions, but there can only be very few questions since time is running. But we already got the first one, so if you please wait for the micro. Thank you.
Thanks. Thank you very much for your interesting talk. I was just wondering, last year or 2 years ago, we had a conference, and there was one of your Dutch friends from the port of Rotterdam, and he explained us very impressively how they did the extension in the Maasvlakte, and they had a very long planning process going on, involving a lot of communities, people trying to overcome these legal obstacles that you have presented here within the framework of the Habitats Directive and the Birds Directive. Is maybe that also possible in your view, you know, that these, of course, restrictive regulatory frames can be, you know, just the frame for creative solutions which try to really balance out economic planning interests and environmental interests? Thanks.
Thank you, that's a very relevant point. Of course, our Dutch friends, they are masters in promoting and selling what they do. I can tell you, and maybe you saw it in one of my slides, one of the projects that also gave rise to very, very serious fundamental legal problems was the second Maasvlakte in Rotterdam. It was also stopped by the court, by a Dutch court, not by the Court of Justice in Europe, but by the Supreme Administrative Court in Holland. And then afterwards, they had to restart the whole process, like it happens so often in Europe, that projects are stopped and then the whole procedure has to start all over again. And of course, they made a deal. And the thing that authorities try to do more and more is to reach a deal with the opponents, to make them happy and to avoid them going to court again. But this is a very tricky thing, because now you saw this compromise proposal in Antwerp of the Flemish government with this tiny little mini dock. And this is accepted by the campaigners that campaign for the preservation of the village, because the village is preserved. And now the government thinks, okay, the problem is solved. We have a deal with the opponents, but no one can guarantee, of course, that there will be not one other, even individual, one single unique inhabitant who is still not happy and might go to court again. So this is a very tricky thing to do. Of course, it worked out in the end very well in Rotterdam, and they have a very nice facility there. We should be very jealous in Antwerp and in Hamburg about the second Maasvlakte, because it's really something that we don't have in our ports. It's such a huge new capacity. And, but in the end, it took a long time. They also did a lot of investment in nature projects and things like that, so they did it in a good way in the end, but they also had their problems.
Thank you very much. There is a second question by Nele Matsluk, and I'm afraid it's the last question due to time constraints, even though there might be never a Brexit, and so maybe you might not have to give the talk tomorrow in Antwerp. But since we want you to be very happy and to come back to Hamburg, we try to, kind of, respect your schedule. Please.
Yes. Thank you for your provoking and thought-provoking talk. I would like to respond to one remark you made when you said, well, birds can fly, but ports cannot, which is of course true. And let me be clear, I fully agree that the Birds and Habitat Directive is outdated, that it should be revised, and it's a kind of a holy cow. I think it should be adapted, it should be possible. We shouldn't have very old legislation that's no longer up to date, that cannot be changed. But if we say, well, ports are important, if you hear the single cases, and we had the same discussion here in Hamburg with some Wasserschierling, I don't know what, even some kind of plant, it helps if it's cute animals, but if it's just plants, people say, oh, look, a port must be much more important. But ports are important. Motorways are important. Cities are important. Renewable energy developments are important. Airports are important. So if you just look at single cases, the economic interest will always win, and that's precisely why we do have a habitats directive, be it outdated or not, in national legislation. So I just wonder, in your specific case, it makes perfect sense to say, oh, look, here port development maybe should have trumped over this village and the directive, but that would always be the case, and then actually we wouldn't need the habitat directive any longer.
That's an argument that I hear very often, but the thing is, in Antwerp, it's special. It's the second port of Europe. It had this huge future development area created back in the 70s with the intention of creating legal certainty for the port and for the customers and for the investors and for the political world as well. And all of a sudden, these environmental rules came in without any attempt at coordinating. And I don't really believe that it is correct to say that in the end the economy will always win. I think here in Antwerp, I think that the port will lose. The port will lose, and everyone in the port is aware that this mini dock is not what the port needs. And I think if we cannot expand this capacity, the containers will go to Rotterdam in the first place. This will create extra motorway traffic because the containers will come anyway. And this will create an extra burden in terms of road pollution in our country, in Holland. Because also one of the advantages of Antwerp and of Hamburg is that these ports are so far inland, so the ships can arrive very close to the final destination, which mitigates the burden of road traffic. So from that point of view as well, it's very often better to have deep inland river ports. But of course, these campaigners, they only look from their own little perspective, and they don't see the broader picture very often. And I'm not sure that in the end the economy always wins. I think it's not going to be like that in this very case.
Thank you very, very much.
Thank you.
I think we absolutely could continue that wonderful discussion quite longer, but I'm afraid you really need to go. The taxi is waiting for you. Have a safe trip back home, and thank you very much for joining that conference. And we hope to see you very soon in Hamburg again. There will be another International Environmental Law Conference in 2 or 3 years, and maybe that's another reason to see us, and we will learn more what happened to the Port of Antwerp. So I think one of the many arguments you made reminded me a bit of planning law, because one of the arguments you displayed was showing that conflicts were not avoided, but they were created by, doing at the same time an extension zone for the harbor and the habitat for the birds. Usually in planning law, we would try to avoid conflicts. This is one of the important purposes. Here one has the imagination that conflicts have been created, and of course this is a problem that is the very core concern of administrative law. And that brings me to not only my next point, but also to our next distinguished speaker, my colleague Katharina Reiling, who is teaching at the University of Constance, and we were lucky that she joined our faculty a couple of semesters ago. No, actually it was last year, wasn't it? Yeah, it was last year. So thank you very much for coming back again to Hamburg, even though the trip from Constance to Hamburg is not that convenient. So thank you very much for taking all the trouble. And you will present from your expertise as an international administrative lawyer, member of an excellence cluster, and a very distinguished colleague in that field, your perspectives on regulation of harbor through the lens of international administrative law. And I think the presentation we just heard and the conflicts that could arise gave proof of the high importance of that administrative law's eyes on not only the planning of harbors. The floor is all yours. Thank you.
Thank you for the introduction. Thanks also to Ivo Appel and the other conference organizers for the invitation to speak here today at the 4th Hamburg International Environmental Law Conference. The topic regulation of harbors normally refers to the international law, port state jurisdiction, as well as to the national ports law and increasingly also the European ports law, at the present Port Package 3. My approach is a different one, since I want to introduce a new perspective on the regulation of harbors. And this is the perspective of international administrative law. So the aim of my presentation this afternoon is to show that the regulation of harbors constitutes a typical object of international administrative law. My thoughts are developed in 4 steps, addressing both international administrative law in general and its realization in the context of harbors. These points include, at first, a look at the concept of international administrative law. Secondly, a summarizing of the role of harbors in maritime governance. Then I will address the elements of international administration which can be found in the context of harbors. And finally, I will inquire the added value of this new perspective. To more information regarding the terminology, I do not distinguish between ports and harbors, but I treat them as synonyms. And I only address harbors as an instrument to regulate the environmental impacts of shipping. International administrative law is not simply a branch of general international law. Rather, international administrative law proceeds from a view what constitutes administration beyond a purely domestic context. However, the term international administrative law is not devoid of ambivalence. In a traditional legal context, international administrative law refers to the internal matters of international organizations. For example, staff issues, budgetary affairs of international organizations. Other early works on international administrative law address the national public law on conflicts of law. Regarding 2 recent works, international administrative law as a research field reflects the impacts of the globalization on administrative activities and on administrative law. These works have strongly been influenced from an American research project based at the NYU School of Law. According to this recent concept, international administrative law forms a 3rd division of administrative law, which can be added to the both common divisions: the national administrative law, representing territoriality, and the European administrative law, representing Europeanization. In contrast to the early concepts, the topics are not only the activities of international organizations and not only national laws, rather it encompasses both levels. In the wording of Eberhard Schmidt-Assmann, international administrative law is to be understood as the administrative law originating under international law and involving processes of reshaping national law and reconstructing international law. The aim of this recent concept is at first to describe and analyze the impacts of the globalization on administration, and then to answer the normative issues of global governance with no worldwide authority in sight. In other words, questions of legitimacy and questions of legal protection against the international administration. And I adopt this reasoned concept. I think the field of maritime governance is the ideal field of reference for international administrative law, since shipping is a typical globalized industry and harbors play an important role in the regulation of shipping, since they combine the ability to regulate ships with some interest to do so. Now, I want to give an overview about the role of harbors in maritime governance by addressing the three topics: port state control, green harbors, and ship waste management in harbors. I will only summarize these topics since other conference speakers deal with them in detail. Port state control is the control of foreign flagged ships in ports by national port state control offices. Port state control does not set any new standards, but enforces the standards which have been developed at the international level. These international standards also concern the protection of the marine environment. Just think of the MARPOL Convention. Where a port state control officer finds deficiencies, the officer may require their rectification, and in serious cases also the detention of the ship or even the banning of the ship from the port. As a consequence of especially the Amoco Cadiz incident, regional port state control regimes have been developed. The idea of such regime is that the elimination of substandard shipping, meaning ships that do not comply with the international standards, would be best achieved by alliances of national port state control authorities. These regimes, which harmonize port state control in a region, do not act on the basis of an international treaty, but their basis are mere agreements between maritime authorities, also known as Memorandum of Understanding, MOU. The first regional agreement of this kind was the Paris MOU. That's the blue one on the graphic. Paris MOU encompasses 27 port state control authorities from Europe, including the Russian Federation and from Canada. The Paris MOU was the model upon which many other regions of the world have established their agreements on port state control, as you can see on the graphic. Despite of their informal character, these port state control MOUs have established their own institutions. Here you can see the structure of the Paris MOU. It includes, for example, an own secretariat and a member committee. A great advantage of these port state control MOUs is that each MOU has its own database with shipping information. In the case of the Paris MOU, it is called FLEETIS, the information system, as you can see on the graphic. This shipping information forms the basis for an innovative weapon, the naming and shaming. It works like this. Once a vessel is detained by a port state control officer, it will appear on the list of detained ships available on the website of the relevant MOU. Here you can see the blacklist of the Paris MOU from 2019. Sometimes there are also reports or pictures of rusty buckets. Here, for example, the ship Bellatrix, which have been banned from the Paris MOU region. The aim of this form of publication is to make maritime industry stakeholders aware of substandard ships and their owners and operators, because the risk of losing profit shall encourage owners and operators to comply with the international standards. Paris MOU is closely linked with the EU. This is because inconsistencies in the application of the Paris MOU led the EU to adopt its directive on port state control in 1995 and this directive rendered port state control mandatory for the EU member states. After the Prestige and the Erika oil tanker disaster, the EU has further enhanced its port state control regime. To give an example, the so-called Erika II package involved the establishment of the European Maritime Safety Agency, EMSA, based in Lisbon. EMSA monitors the implementation of the EU port state control regime, and EMSA also manages, hosts, and operates the database of the Paris MOU thesis. The International Maritime Organization, IMO, encouraged the worldwide harmonization of port state control. For example, the IMO procedures on port state control are basic guidances on the conduct of port state control inspections, and every 2 years the IMO hosts workshops for port state control MOU secretaries and database managers. These IMO workshops, they form a kind of platform for cooperation and provide a forum for the regional MOUs to exchange ideas and experiences. My next example are green ports. I will address 2 points: eco ports and green port fees. EcoPorts is a regional network of port authorities for sharing experiences in port environmental management. It was initiated by a number of proactive ports in 1997 and has now been fully integrated in the European Seaports Organization, ESPO, since 2011. EcoPorts also fosters port services aiming to encourage greener shipping, and for this reason it offers a toolkit which encompasses a self-audit system. It has developed environmental performance indicators to measure the green performance of its member ports, and it also offers an environmental assessment by independent auditors called PERS. So the good green ports get a PERS certificate. Hamburg does not have a PERS certificate, but I think the Jade port has one. An instrument used by many port authorities are green port fees. The principle of green port fees is to charge lower fees to ships that are less polluting. In most cases, this is done by a deduction of the regular port fees, either as a fixed amount or as a proportional deduction. For example, the cleanest ships get a 10% rebate on the regular port fee. Sweden was the front runner, but nowadays green port fees are widely used. About 28 of the major world ports apply them. However, green port fees are a highly controversial instrument since their efficiency isn't clear. This is because of different green port fees approaches, and another reason is that the difference in fees for the dirtiest and the cleanest ships is usually very small, normally in the order of 5% to 20%, and this leads to the risk of mere deadweight effects. So recently, the OECD and the EU strongly advocate a harmonized and stricter approach of green port fees. My last example addresses ship waste management and harbors. Port reception facilities receive several types of waste generated from a seagoing vessel, so the presence of port reception facilities is an integral precondition to minimize waste discharges into the sea by ships. Hence, the Marpol Convention Annex 5 says that port states have the obligation to provide port reception facilities. Globally, port reception facilities are managed in very different ways. Even in a single harbor, not all port reception facilities are managed centrally, but often by a myriad of public and also commercial groups. However, there are approaches to harmonize the different management approaches of port reception facilities. To give an example, several regional regimes support a harmonized fee system called the no special fee system, and the system shall encourage the use of port reception facilities. Such a no special fee system is an indirect charging system where costs of reception, handling, and disposal of ship-generated wastes are regularly included in the port fee. You can compare such a no special fee system with a flat rate because the waste delivery is levied on every ship calling at the port irrespective of the actual use of the port reception facility. So since no additional costs are imposed on ships using the port reception facility, a no special fee system provides incentives to discharge waste onshore and not offshore. Such a no special fee system has been recommended under the framework of the Helsinki Convention and the proposal for the revision of the EU Port Reception Facility Directive provides for a 100 no special fee system. I have summarized the role of harbors in maritime governance. So, is this international administration? The concept of international administrative law approaches the question of what constitutes the international administration by describing particular elements. In the following, I want to show that these elements can be found in the regulation of harbors. These elements address the organization, the instruments, and the law of the international administration. According to Sabino Cassese, the international administration has a marbled structure. This means that there is a great variety of actors involved next to domestic regulatory agencies, private and even hybrid actors are part of the international administration. Many international organizations also engage, and furthermore, one can observe a growing cooperation of public authorities in the form of transnational networks. In contrast to the common notion of national administration, there is no hierarchical link between all these actors. This is why the structure is marbled, according to Sabino Cassese. Regarding harbors, we could see that the starting point of regulatory activities are such transnational networks of public authorities, the port state control regimes, and eco-ports. Private actors can also be involved, for example, in the management of port reception facilities. Despite of these transnational networks, there are still cross-national discrepancies which can distort the market by promoting the so-called port shopping phenomenon. This is a strategy used by ships or ship operators who prefer certain ports over others because of their less stringent regulation. And this problem sets the starting point for international organizations like the IMO or for regional actors like the EU who aim to harmonize the different regulatory activities in harbors. The IMO has an overarching but not a hierarchical function. Just think of port state control. The IMO only constitutes a forum for the regional port state control MOUs in order to harmonize the port state control globally. And the IMO does not control the port state control regulation of the EU either. Rather, the EU pursues more and more its own port state control approach. So we can say we have a marbled structure in the context of harbors. The international administration often uses positive and negative incentives to enforce international standards. The reason is that globalized industry are difficult to regulate since they act in different states and they can easily devise avoidance strategies. And this difficult enforcement situation suggests the need to develop incentive-based instruments. The idea of such incentive-based instruments is, or the reason is, that they do not exclusively rely on public authorities' activities. I will clarify this idea of incentives with the example of naming and shaming. In the case of naming and shaming, public authorities only have to publicize infringements on the internet, and the market system sanctions the infringing companies by avoiding any business connections with them. That's the idea. Hence, there are, in theory, negative incentives that can foster the worldwide enforcement situation. Regarding harbors, the Port State Control MOUs use the instrument of naming and shaming, and in interviews, Port State Control officers and the Paris MOU said that it would be a highly effective instrument to improve enforcement. And furthermore, green port fees and the no special fee system constitute example of positive incentives. So we have this instrument. Some international administrative law derives from standard sources of law. The law can be found on the international as well as at the national level or regional level. However, many of the features of the international administrative law have evolved as part of the mere practices of international organizations, transnational networks, or forms of private lawmaking. Hence, legal pluralism and informality characterize the law of the international administration. Regarding harbors, we've seen that different forms of hard law, like the Marpol Convention, EU directives, and national law, like the Schiffsabfallgesetz, refer to the environmental protection in and through harbors. And furthermore, soft law like the MOUs or the IMO port state control procedures play a significant role because they harmonize the different approaches in the regulatory activities of harbors. So we also have the typical law of the international administration. The single phenomena that I have summarized in the second part of my presentation are well known. So what is the added value to describe and analyze the regulation of harbors from the perspective of international administrative law? At first, international administrative law underlines that the regulation of harbors is embedded in a plethora of actors and legal layers. Harbors are not actors that are controlled by other actors. Rather, harbors are points of entry, and in this function, they constitute starting points for regulatory activities on different levels, and this includes forms of self-regulation. Secondly, the perspective of international administrative law can draw the attention to typical administrative problems. I want to clarify this thesis with the example of naming and shaming under the Paris MOU. Naming and shaming raises the question of legal protection against false accusations. To give an example, a port state control officer in Hamburg detains the ship Queen of the Seas, IMO number 1234567. However, because of a mistake, the wrong ship, the ship Daisy, IMO number 1234568, appears on the blacklist of the Paris MOU. So what can the ship owner, the ship operator can do? In the national setting, the entities affected can seek judicial review also against naming and shaming, at least in Germany. However, obtaining judicial protection against the international administration is much more difficult because of the plenty of actors involved and because of the informal character of the international administration. I will explain this in the following. Under the Paris MOU, the Secretariat, which is based in the Netherlands, in The Hague, publicizes the shipping information, whereas the national port state control authorities in Germany, the BG Verkehr, Dienststelle Schiffssicherheit, provide the shipping information. So against which party could an action be brought? Since the national port state control authorities detain and ban the ships, route to legal protection against or before national courts have to be considered. However, there are several problems. Even if the detention was illegal, can national port state control authorities correct the naming and shaming on the website of the Paris MOU? And what is if the naming and shaming is illegal because of a mistake of the Paris MOU Secretariat or because of a mistake of the common database THETIS, which is managed by EMSA? Alternatively, proceedings could be brought against the Paris MOU because the real harm is caused by the centralized publication in the form of blacklists, reports, and pictures, but this presupposes that the Paris MOU has separate legal personality, and this is very doubtful. Despite of their own institution, it remains a mere informal agreement between public authorities. How to give effective legal protection against the international administration is a highly controversial issue. In my opinion, due to the problems of judicial review against the international administration, one should consider alternative forms of legal protection. The context of Habes illustrates that alternative forms of legal protection can work. The port state control MOUs offer our own appeal procedure, which is called the detention review procedure. This detention review procedure does not cause the detention or banning of the ship to be suspended, but the ship owners and operators can get the correction of the wrong shipping information in the common database of the relevant port state control MOU. Under the Paris MOU, there are about 30 detention review procedures in a year. So, international administrative law can illustrate that there are many difficulties regarding judicial review against the international administration. Thank you for your attention.
Dear Mrs. Reiling, thank you very much for that wonderful theoretical framework that you also provided to our topic. I think international administrative law is a very advanced concept of theory building, and it can be a very helpful instrument to really shed light on, the things that we are discussing here and how we can theoretically frame them. And it was very interesting to learn how you managed to break down the theoretical concept to the concrete and very precise questions of harbor governance, so to say, and the role of green harbors and port state responsibility and so on. I think it is a wonderful accident that you spoke quite a lot about the Maritime Safety Agency, and our next speaker, Professor Ringbaum, has been working as a head of unit for marine environment training and statistics at the European Maritime Safety Agency in Lisbon. So you are also a practitioner and an expert in that field, now working as adjunct professor at the Arctic University of Norway, the Jepsen Center for the Law of the Sea, and since 2012, if I'm correctly informed, also part-time professor at the Scandinavian Institute of Maritime Law in Oslo. So another renowned expert that now in the next step will concretize our topic to port state jurisdiction and port state responsibility. And I'm quite excited to learn whether there might be some links to the international administrative law approach that we just got to know. The floor is all yours. Thank you.
Thank you very much. And thank you to the whole organizing committee for the opportunity to be here. I might make some links to administrative law. Certainly some of the topics will touch upon topics that were just discussed and will be discussed tomorrow as well. But really, I think this presentation is quite different from the two other ones in this session, because this is really about the states. This is here. It is the state that is the active party, and in relation to other states. Port state jurisdiction is about public international law, mostly, but not only law of the sea. And so this is going to be back to where we started, in fact, to UNCLOS and this type of matters. It doesn't start well. I realize that one of my affiliation is not on the screen there, but in the program it is correct, and how you introduced me was correct. The Tromsø affiliation is missing there, unfortunately, but that's a mistake from my side. Yes. So why do I talk about port state jurisdiction? Well, apart from the obvious fact that I was invited to talk about port state jurisdiction, but I think it's one of the most fascinating fields to study if one is interested in the dynamics of shipping regulation, basically at international level. This is where all the action is, I would dare to say, even in the field of port state jurisdiction. Because to make it a caricature, it a bit basically regulating flag state has the drawback, and you will never get a complete coverage in that way. And the Law of the Sea Convention basically put the lid on what coastal states can do, that is for ships only passing along with your coast, but left the question of port state jurisdiction. How far can port state regulate foreign ships that come to your ports? Left that question almost completely open, which has in its wake resulted in quite interesting development. Not all of this is dependent on the Law of the Sea Convention. Some of the port state jurisdiction exercises are quite old, 100 years old and so forth, the well-known examples. But I think there has been a marked acceleration of the use of this type of rules in the past 2 or so decades, and that's the period I intend to cover here. Basically, what I try to do is to, following a general introduction of the concept as such, I will just illustrate by means of some examples what has happened in practice, how port state jurisdiction has been used, and in what format and what context, even noting a little bit of potential future challenges to its use. But then the second, towards the end of the presentation, I will then discuss the legal limitations of this, because it is really about, there is some uncertainty about how far states actually can exercise port state jurisdiction. And I think that is, well, that covers it. Then there will be some conclusions, obviously, towards the end. So I think one needs to separate a little bit, because quite often it's mixed up, the concept of port state control, which we just heard about, and port state jurisdiction. I think port state control in my world is a very sort of technical task of exercising control of international rules on ships that come to the ports. So it's not really about challenging the international rules in any way or inventing new rules. It's about making sure that they work, because the flag states are not trusted. Port states come in as a second line of defense to check the same thing as the flag states ought to have been doing. That is port state control. Port state jurisdiction is going further than that. That is making jurisdictional use of the presence of the ship in the port to actually impose rules on it. That's the prescriptive part of port state jurisdiction. as you know, UNCLOS has separate rules for prescriptive jurisdiction, what laws can a state make, and enforcement. How will those rules be implemented in practice? And so I'll start immediately with the review of general development, because it's quite broad, and I might not even be able to cover it all. It's quite, also from an academic point of view, it's quite a good time to speak about this now, because we have recently had 2 very solid PhD theses written and published at the University of Utrecht in the Netherlands about port-state jurisdiction, one dealing specifically with fisheries, and the other one more with commercial shipping and in particular environmental requirements. But this development takes place in other areas too. I will cover maritime safety and environmental rules, both internationally and at EU, then fisheries, maybe say a word or two of international private law, and there are some other examples as well coming up now, for instance, using port-state jurisdiction as a basis for requiring salary and social conditions for crew working on ships that are closely linked to the port in question and so forth. So it goes beyond these topics. And the focus of my review is international rules and EU rules. I don't go into national examples here. Starting with the IMO conventions, I mean, from this point of view, you can maybe divide them into 2 different categories. You have the old style IMO conventions, which didn't mention this at all. They were developed for flag state and put down the minimum requirements for flag states, and a little bit of port state control on that. And that was it basically. But they also included a very interesting provision, which was called the no more favorable treatment clause. Almost all IMO conventions include that. And that clause says that you should treat parties to the convention, ships flying the flag of a party to the convention, in the same way as non-parties. And of course you couldn't do that under treaty law, because you cannot in one treaty create obligations for non-parties. But the reason why you still can do it is because of port state jurisdiction. There is a possibility for port states to exercise the jurisdiction because the ship is voluntarily there in their port. And through that, even if it hasn't been made so explicit, this system has been working for decades and has been well accepted. More recent conventions in IMO, in fact, specifically deal with this question, and usually in the form that they say that in this convention we don't, this convention does not preclude the right of port states to go beyond and to actually impose further regulations. We have some examples of those sort of rules. So they have started to acknowledge the sort of residual jurisdiction that port states have, in addition to the rules that have been agreed in the conventions. But for the IMO conventions, of course, a critical question remains that is this IMO convention, if states agree in an IMO convention about a certain rule, for instance, that ships should have double hulls, can port states then, through exercising port state jurisdiction, agree on something else, that they should have triple hull when they come to your ports? I mean, this is of course not a real example, but it raises the question whether the convention represents a kind of package deal or whether it is just a minimum requirement which state may depart from as port states if they want. And that question is not very easy to answer, and I think that there are many elements to it that I will come back to some of them. But generally, the biggest purpose of port state jurisdiction is the biggest consumer of port state jurisdiction is not the IMO, because they can make their rules if they need that. They can use the flag state and cover the whole world through that. The biggest consumer of port state jurisdiction are states that are unhappy with the existing rules, whether it's IMO rules or some other rules, and want to do something more, different, better. And they, of course, don't want to do it for their own flags only, because that would put them in a disadvantageous situation. And they cannot do it, in most cases, for passing ships. But through port state jurisdiction, they have this possibility. And in fact, this is the basis of the European Union's entire maritime safety policy, is basically to implement rules for any ship, irrespective of nationality, that come to EU ports. Some 30 out of 40 directives have this element. They are basically regulating all ships in this way. And there, of course, lies the big benefit in being a large area, doing it jointly, that you avoid the risk that by implementing rules very strictly, the ships, if you're a small state like Belgium, would do it alone. It would only mean that ships would prefer to go to Holland instead. But if you are 27 states acting together, that risk is very much diminished. Well, still, most of the EU rules are very closely linked to international IMO rules, but I'll try to show in two pictures that follow that in the most active period of EU legislation, it was 12 years, there has been increasing independence, both in terms of what rules are required, but also how they are enforced. I have indicated there on the vertical axis 4 different stages. One is just implementing international rules, like the Port State Control Directive does. Then the next step is making non-binding international rules binding for ships coming to EU waters. That is going a bit further. But still further is to complement the international rules by additional rules, well, like the Port Waste Reception Facilities Directive, where the international rules are quite vague, and EU rules specify a lot of things in addition. And then the last one is competing with the international rules, where international rules says something and EU rules says something different. The final step there is violation of the international rules, but I haven't dared to put it there. But you can see that there is a trend in development here. These are the port state directives that are most easy to place, and in this period, clearly there is a tendency to be more and more independent of the international rules. In fact, the EU has even done an interesting thing. They have created a completely new concept, which is called the host state concept, which goes even further. And that is nothing to do with the law of the sea. It comes from the EU law on provision of services, basically. And they have implemented for passenger ships in particular, that in order for a passenger ship to provide a service, it needs to fulfill certain, between or to or from one EU port, it needs to fulfill a number of additional criteria. But the same thing on the enforcement side. If you just think that if somebody violates the rules, what is the consequence? First, you can have just control. That was originally the method to do it. Then you could start doing various conditions for when the ship can leave. You can even start detaining it. That came with the Port State Control Directive. You can start banning it from all European ports in certain conditions. And then you have the passenger ship services. But then you can also refuse access to the port altogether, which is even more dramatic. and you can have that for an individual port or for all EU port. And finally, you can have criminal sanctions against. And here again, quite a clear development and the reason why the development stops there is that there were some more directives adopted in 2009 in particular, but since then they were not particularly challenging from this point of view, and since then there hasn't been very much legislative activity in the EU. There is one instrument in particular which is interesting, and that has to do with climate change, the so-called MRV regulation about monitoring and reporting and verifying ships' emissions for ships coming to EU port. It is clearly up there, relatively high on both of these scales, because it says that if a ship does not comply with these reporting requirements, it will eventually be banned from all EU ports. And that was adopted in 2015, before the corresponding IMO rules were adopted. So that was the EU. In fisheries, there has been a somewhat similar development. I think what was most interesting with the fish stocks agreement that was adopted in 1995 was that it recognized this port state jurisdiction as a right, but also as a duty for states. That port states had a duty to make sure that fishing vessels of all flags actually complied with the required standards. And what exactly this means were then set out in certain voluntary standards, first in 2001 and then in 2005. But finally, in 2009, there was the Port State Measures Agreement agreed within the Food and Agriculture Organization, and that entered into force in 2016. And that provides for some details on how port states shall make sure that their duties and rights are implemented. Basically, a starting point has been that ships that are engaged in IUU fishing should not be allowed. This is at least the European interpretation of this rule, that they should not be allowed to enter ports, in EU ports, or land their catches in EU ports if they do not comply with the fishery standards. Other states have subsequently been going further with different types of sanctions for non-complying fishing vessels that want to come to ports. There is an interesting thing also with the European measure on port states, because it also, through its sanctions as a port state, it sanctions states who do not fulfill their port state obligations. So it's not only when states do not meet their obligations as fishing flag states that they are sanctioned, but also when they don't meet the port state obligation, even for non-parties to the agreements, the Port Sea Measures Agreement, which is quite interesting. And it kind of sort of double acts on the port state jurisdiction. I'm stressing a bit here because I want to discuss the legal issues thoroughly. Well, let's not go into this now. It's basically just to indicate that in this area too, when it comes to employment contracts in European regulation, it is far from clear as it once was that it's usually the flag state that governs, that is the applicable law for employment contracts if a particular choice of law has not been made in the contract itself. More and more it comes down to other types of criteria, and these are increasingly being used also by courts in practice. Then we have another category of port state jurisdiction developments, which is different. First, there are certain of the United Nations Security Council resolutions that oblige all states to actually take various types of port state measures against ships that do not meet various sanction requirements with respect to North Korea and Yemen. In particular, North Korea, there is a whole range of these, the latest ones being from 2017, and Yemen is from 2015. It goes further also, it requires it to inspect and actually seize the cargo of ships that are found to be violating the sanctions. But from a jurisdiction point of view, these are not particularly problematic, I think, because this is United Nations Charter, Chapter 7, Security Council adopts, and basically this wins over any general considerations of law of the sea or port state jurisdiction. But some examples exist also relating to this type of political sanctions without such backing in Security Council. There are probably other examples as well, but one quite interesting is when several Persian Gulf countries decided to start sanctioning Qatar for its activities as they claimed in supporting terrorism and not doing what it could to, representing a security threat in the region. Among the sanctions to be implemented were all sorts of port state, quite drastic port state measures. Ships that were from Qatar were banned from the ports of the countries, but also ships coming from a port in Qatar or going to a port in Qatar, and in some cases even relating to the cargo carried. And this is, of course, a very different thing if you don't have a Security Council resolution backing in justifying this type of very far-reaching goals for security reasons against a particular state on the basis of port state jurisdiction. That your ship comes here, it doesn't have a right to be here, so we can do it. I wanted to spend 1 minute also to look a little bit ahead, because now these previous slides have been sort of a very brief review of what has happened in various areas in the recent past. But I think that there are several reasons to believe that port state jurisdiction has not reached its peak at all. In fact, it's probably going to be even more attractive for states to be used as a tool for regulating maritime traffic in the future. And the main reason for that, I think, is simply technology. It is so much easier now than it ever used to be to have control of where ships are, how they are trading and what they are doing. Because that, of course, was a big problem some decades ago only, that a ship was in port, but how on earth could you know for sure where it had been and what it had been doing? Now, through various types of databases and satellite systems and all sorts of monitoring tools, it's quite easy to check out what ships have been doing and then enforce it when it comes to port. In particular on the high seas, where there has been a big problem in the past, where nobody really has had jurisdiction. So there is a kind of a push towards regulating what happens on the high seas or enforcing it also in this way. For example, we talked about navigation in the Arctic. If you would want to have some particular rules for ships traveling in the Arctic, for instance, the European Union, it doesn't have a coastal area in that region, but most of the ships that are in through traffic in the northern sea route would have a European port as a start or end port. So I mean, that could be an example of how port state jurisdiction could be used in this extraterritorial manner in the future. The most hyped regulatory discussion for the moment is, of course, the marine autonomous surface ships, the automated ships or remotely controlled ships. It raises some questions of Law of the Sea Convention, but as opposed to some lawyers, I don't think the Law of the Sea Convention in any way prevents this development. But it does require that IMO is on board, and that it sort of endorses it. But there are some interesting consequences. What do you do with when you have jurisdiction over the ship, if we talk about remotely operated ship, but you don't have jurisdiction over the people who drive the ship? I mean, because they might be sitting in a different world altogether, and this might give rise to completely new type of enforcement measures needed also. So, but again, I think port state jurisdiction, both as a regulating tool and as an enforcement tool, will be very critical in developing any new mechanisms to cater for also this development. So then, all this happens and is likely to continue happening, but what are the limits? What are the responsibilities of the port state? But where does the law come against this and say, this goes too far? There is not really a very good answer to this, or a simple answer to this question, unfortunately. Probably the easiest answer relates to enforcement, what measures states can take with respect to ships that are in their port, because we have a lot of very important rules in the Law of the Sea Convention, which are generally accepted, the safeguards in Part 12, and the tribunal has also in the Virginia G case stated that even if this is part of the Part 12 of the convention, basically these safeguards apply to other enforcement measures as well. And we have also examples of various types of restraints and limitations on port states in exercising enforcement. But we don't have any case law really at the international level about the prescription side. How many requirements can a port state place? Not even at national level are there judgments on this. I know of only two, and they go in the opposite direction. One is Swedish and one is from New Zealand, and they say completely different things. But I think at least that this development that I just outlined on the very significant development of how this jurisdiction has been used in practice has had an effect also on customary law since UNCLOS was adopted. And let's look at the question now. I think I have 5 more minutes. Don't you? First, the starting point when starting to analyze this question is of course that ports are located in the internal waters. It's part of the territorial sovereignty of the states, and there is no access for ships to go to foreign ports. There is no right to access ports under international law. And of course, if there is no right to access port, that implies that there is also a right for the port state to place conditions on the access. But as I mentioned, UNCLOS is very unspecific on this matter. It hardly deals with it at all. Just some indications in those two articles or paragraphs I mentioned there. And the IMO conventions before a certain date did not really deal with this aspect either, as I also mentioned. So they don't really help very much in putting those limits. I mean, the IMO conventions are drafted always as minimum standards for the flag states. But whether they are also maximum standards for the port state, they don't say. And arguably, they should say it if they are supposed to represent such kind of infringement or intrusion to the jurisdiction of the port states. But there may be other types of international law, of course, that puts limitation. There is quite a lot of bilateral agreements between states about providing access and equal treatment and all this. And then, of course, we have the whole WTO body of laws, which may be implicated in this sort, because it's also based on non-discrimination and national treatment and this sort of thing. So if you start singling out certain types of ships or certain nationalities in particular, you will very quickly have problems also in that field. And there are some interesting cases in the dispute settlement body of the WTO which can be used as a parallel for this unilateralism / multilateralism discussion that we have here. But some requirements apply irrespectively. You cannot discriminate, really. This is, I suppose, the biggest problem with the Qatar, that you cannot single out under the law of the sea, at least a single nation and discriminate against that. There is also a prohibition of use of right, and there are different types of international legal requirement on proportionality and reasonableness. So these would apply in any case. But then if there are no other treaties that apply to the question, we are still faced with this main issue on what can a port state do. And basically you had two approaches here under the law of the sea convention. One says that, well, you need a prescriptive basis to do it, which means that you cannot do it for areas beyond your exclusive economic zone, at least for requirements there. But the other one says that, well, you don't have to come here if you don't like our rules, but if you come here, we impose our rules, and it's a bit more subtle than that. But that is basically the two approaches that you can find as a starting point. I think it is also important to bear in mind that the relevance of the argument depends on what type of rules we are talking about. Are they static? Are they the same rules, like the double hull requirement for a tanker? If a port state says that we don't only want double hull requirement tankers in our port, it means, of course, that the ship will have to be double hull tanker all the time, because you cannot change. But on the other hand, it's easier to argue for that sort of rules, because then you can say that, well, the port state said that we are only regulating our port. It's just a coincidence that it happens to apply everywhere else, but you are violating the rule here. With discharges, it's more tricky, but there you have a specific UNCLOS provision which gives extraterritorial jurisdiction. And the biggest legal problem, I think, is when it comes to rules that are not discharges, but not construction rules either. They are operational rules relating to how ships behave away from the port state's own jurisdiction. you can also say that this is not really about the law of the sea at all. You don't have to resolve it within that context, because the law of the sea convention itself says that there is whatever is not regulated here is regulated by general international law, and that has other types of rules for extraterritorial jurisdiction that could be relevant here. And it also is relevant what type of measures the port state takes to violate, to sanction against the ship that violates the rules. Because if you are only saying no to access to ports, for example, or access to services to which the ship has no right, it's easier than to issue a fine, for example, because then you would have to motivate it much more clearly why you have the jurisdiction of the extraterritorial jurisdiction. And these are not necessarily, I mean, the most stringent enforcement measures, like banning a ship from all ports in the region, they are easier to justify than a simple fine, even if a simple fine would probably be much more preferred by a ship. So you can arrive at the result of this question from various points of view. You can arrive it from the law of the sea, you can arrive it from general international law or international trade law, but in the end the principles will be very similar, and that is the outcome of my research in this field, that it's in the end it boils down to the same type of balancing of interest between the port state and the international interests. So my concluding slide says that legality ultimately depends on the nature of the obligation, on the chosen methods to enforce it, and on the general reasonableness, etc. But also more academics start to emphasize the objective of the measure. Is it for the common good? It might be easier to justify than if it's for purely national interests. I shall not speak very much about this, but this is my last slide. I just highlight it because this is a list of potential interests that need to be taken into account when this assessment is made by a court in assessing, in my view, under any of these principles, if the port state actually overstepped the border of legality when it introduced these measures. The only point I would like to make, and that's my final one, is the last point there. Because I think it's obvious that any type of balancing between these questions will depend on whether you bring the case to the International Tribunal for the Law of the Sea, or the International Court of Justice, or the European Court of Justice, or the WTO dispute settlement body. So you really have a case of forum shopping when it comes to port state jurisdiction, which is interesting in itself. I'll stop here. Thank you very much.
Thank you very much. Thanks. Please take a seat here on the stage, and if I may invite Mrs. Reiling also to join us for the question and answer session. I think we again heard a very detailed and a very interesting presentation, also showing us, that very different fields of law, maybe fragmented fields of law, govern port state jurisdiction, and that, overcoming these fragmentations might be an interesting issue, but there is also a very interesting aspect of forum shopping, not which country will we go to, but which legal regime will we prefer. And I find it a very exciting topic also from a theoretical point of view for a general public international lawyer. And I'm sure that you might have quite a lot of questions. So the floor is open, and please, if you maybe briefly introduce yourself, your name and your position, that everybody gets to know you a bit further. Thank you very much. The floor is all yours.
Katwa, I have no position. I'm retired, but I know a bit the subject. But coming as a diplomat to maritime affairs is, of course, a dangerous matter. I have two practical questions. One has been discussed a little bit. What is the loss of efficiency through the overlapping rules and regulations? And the other point, in my view, has not been approached at all. That is the practical implementation. Is anyone knowing a country which has the qualified personnel to do the port state control, who has the equipment, the technological and other equipment, and third, has the will to cooperate between the different types of port state control? Because if you go on a ship and you find out, or you go for control of oil spilling or things like that, and you find out there's another type of security problem of manning, of I don't know what, of fishing, and so on. We have all over the world these boundaries between different administrative things. And if I hear international administrative law, and I have my 40 years of administrative implementation and how people do not cooperate or have not the necessary equipment or do not have the formation and all that. So that is my point. Where is the practice?
Thank you very much. The famous litmus test of, practicability and of efficiency. I think both panelists will have answers to that question, or maybe further questions to that question. But before we answer, I'd like to collect the second question by Alexander Preuss, please.
Thank you. Thanks for the two great talks. One question to each speaker. I was thrilled by the idea of international administrative law as a theoretical concept. I understood that it is extremely helpful in order to describe the complex situation as it stands, but I wonder whether it also provides solutions. It helps us to understand, completely clear, but does it also provide instruments that would help to tackle fragmentation between the different legal layers or something the like? And that is something I didn't fully get, so I would be very grateful for a short comment on that. The second question to Hendrik. Is state practice, when it comes to custom following UNCLOS, is state practice really that uniform? Doesn't the fact that there is a provision in the UNCLOS concerning discharge from ships, which explicitly entitles port states to take measures, doesn't that imply that in other situations where such a competence is not granted to port states, it simply doesn't exist? Which means that that port states would then overstep their competence and act illegally. And my second, if I may, very, very, very briefly, this is a discussion we had a couple of times in the past, and that has to do with the so-called autonomy of European Union law. You referred to the forum shopping issue at the end of your talk, and I was wondering, is there still any discussion on whether the conduct of the EU is in accordance with international law, or has that cookie been eaten? Thanks.
Thank you very much. I think in particular your solutions question is strongly related to the practicability question and the practicability issue, which is very exciting. And maybe there's a third question in that regard. I'm very happy to take a third one, and then our panelists have the first chance to answer. Please.
Thank you very much.
Yeah, it works.
Yeah, it's okay. Suzette Suarez for Hochschule. I teach at Hochschule Bremen. I have been doing law of the sea and maritime law for many years now, and I have hundreds perhaps of questions or some thoughts going on, hearing both presentations today. And unfortunately, the first presenter is not here anymore. Would have been also good to have him sit there right now. But anyway, I have perhaps some for Professor Ringboom, and of course also for Dr. Reiling. One idea that I got for Professor Ringboom's presentation is that this idea of port state control and jurisdiction, that it's a kind of one-man show somehow, although I'm sure that was not your intention. because you spoke of the limits of what could a port state do or prescribe or enforce. So there's this kind of idea that it's a kind of one-man show, although it's not. And the other presentation from Dr. Riley, which I also enjoyed very much, because it's something that, you know, this kind of idea of international administrative law is not something that law of the sea lawyers normally do. But actually, we do a lot of administrative law, because that's, you know, I think the idea of law of the sea is how do you implement this convention? It's quite broad. There's so many details to this, and how do you implement this? You have to do it through administrative law, of course. But anyway, the idea that I've got from your presentation, of course, is that it's not a one-man show, because you have mentioned your example mainly was really the port state MOUs that exist, that have been in existence, and which you also describe as rather informal, not because there are MOUs and not really treaties, so perhaps not a kind of soft law as far as you're concerned. This is the idea that I got. And both are actually, of course, perfect. They have, yeah. So my question was really now is that, Professor Ringbaum, you mentioned technology as the, you know, it's there that would facilitate port state control or port state jurisdiction. And I've just quickly looked in my, thank you for the internet connection here, just to quickly look what is the current situation with FILE, the Facilitation Convention at the IMO, because it's intentionally, originally for maritime traffic to facilitate traffic. So port authorities would have to, you know, require some processes from all ships that would dock into there, but now they are also actually, because of technology is enabling these ports to perhaps do more than facilitate maritime traffic in terms of just looking at the other, I don't know, cargo or the more trade aspects to shipping, but even environmental control. And I just looked, there is a, you know, also forms for, they have to now submit, I don't know, the waste facility, for example. So there's the environmental control there now through this facilitation convention. So as far as I know, technology is making this possible. So my question to both of you is, how do you actually see technology's role now for port states to you know, control shipping, or for other purposes, even fisheries, for example? What is technology's role in this? Thank you.
Thank you very much. And I think in particular the technology question again is a very practical one. But maybe Mrs. Reiling, you start answering that very complex set of questions third, and then Professor Ringbaum.
Yes, I think the first two questions both concern the issue of fragmentation in maritime governance, and yeah, it's a great problem, as you can see in the case of port state control MOUs. The IMO is not a hierarchical institution who can say we have a worldwide port state control and the procedures are just soft law, they're not binding and so on. In the context of the EU, we have the EU who can harmonize port state control very effectively. As we have seen, there are, oh, I forgot the English word, Vertragsverletzungsverfahren, in case of the Port State Control Directive. We have to, yes, exactly, thank you. Or the EMSA or such institutions, and such forms of the European law can foster harmonization, but we don't have this in the global context. And what's the solution? International law does not offer the solution. I think what the advantage is that it can raise awareness of the problems, because it says, okay, we have administration, but this administration is a kind of, it's kind of different from the national one. There's no top-down approach. We don't have a worldwide authority. So we have to solve the problem of harmonization, fragmentation in a different way. And in the case of the port state control MOUs, you can see there are several approaches to harmonize it. The IMO workshops, there are several attempts of the Paris MOU and Tokyo MOU who want to combine their common databases to have a more harmonized approach, not just in the region of the Paris MOU or the Tokyo MOU, but both ones, though there are several approaches. They're more like, I would say it's kind of interlinkages between the different actors, regimes who can foster harmonization. It's not the solution we want to have. It's not the end of fragmentation, but I think I'm not that pessimistic. I think it can work, but it will take its time. And the third question, I don't know, it was about the soft law thing, or was it a statement, or yes, I think that's the big issue regarding legal protection. I would say it's soft law. When you look at the Paris MOU, the addressees are the maritime authorities from Germany, France, and so on, and so. Yes, yes, that's I don't know. Do you have a special perspective or issue, or I was not that sure. I do not have. I agree with you in so many ways. Okay.
The only thing is that maybe both of you maybe would have to start. Yeah, I'm just saying that, but my point really was about the technology right now that's available to the ports, because now it's not that ports would be necessarily doing one very special thing, you know, not just because of the MOU, but because of technology would enable them to really join forces. Like you just mentioned, the database, you know, sharing of the databases. So it's not that ports would be doing their own thing, but there's more harmonization through technology, because it would just happen. That was really my point. What do you see the role of technology there in port state control?
I mentioned the databases of the Paris MOU and Tokyo MOU, and that's an approach. They try to harmonize it. So technology is a big thing to foster harmonization. Yes.
Yeah, thank you very much. By the way, the Vertragsverletzungsverfahren you mentioned is infringement procedure. So, but I just was also kind of, you know, having a kind of blackout or whatever. Professor Ringbaum, your answer is very exciting, very interesting, and of course, again, the tricky real-world practitioner's question, or at least practical questions.
Yes, thank you. I think your answer to the first question was so good, so I should just complement a little bit on this aspect of collaboration between various administrative regions. There's one forum for collaboration which I'm particularly fond of when it comes to this port state control. It's a database, a common database for all port state control information providers, which is called Equasis. Everybody can access that and look at what data, what shape has been detained, and all the MOUs participate in the editorial board of that body, and so at least in the form of data, there is a very good experience of actually collaborating and doing useful work and harmonizing work. But of course, in the substantive sense, I think this is a challenge, because it always was the case that Paris MOU was kind of the first one to develop very sophisticated system, and Tokyo MOU very closely after. But then there was a big gap to the remaining ones, and that has become even more evident now with the development of the new Thetis database and all that. I don't think it's simply possible to demand from all port state control authorities to have that sort of systems in place, and I think it's good that there is increased attention from the IMO to actually ensure coordination between them, but harmonizing, I don't see any prospect of doing. On the contrary, I think the divergence between them are growing more by the day. Well, Alexander's questions, two. Yes, the first one about whether Article 218 of the Law of the Sea Convention, in fact, a contrario, suggests that there is no port state jurisdiction. It comes back to the, well, first of all, you could argue that maybe so, but that is probably then only big for discharges, because that provision deals with discharges, and rules that are not discharges wouldn't really be covered by that logic. But also, I think it comes back to that main dichotomy that I mentioned, that there are basic two starting points really when looking at this issue. One says that you need to have a prescriptive basis in the Law of the Sea Convention to accept any kind of port state jurisdiction. This is what you imply with your question. The other says that no, this is about do we allow ships to our port or not, and then it doesn't really matter if we have we just close the door outside our port, and that is really what we're doing. And that discussion can go on for quite a long time, but I think it's a bit tricky. What makes it more difficult, this whole discussion, is that the most powerful measures that the port state can take are the easiest one to justify because of this construction, etc. While the lighter ones raise all these questions about extraterritoriality, etc. But I think state practice will eventually resolve it together with cases that we will. But right now there is not really a good answer to that question. And as I said, I think different courts would come to different conclusions on that question. The second question is whether the discussion on whether EU law is lawful under the Law of the Sea Convention is already over. I think it will come back again at some point, but for now there is no such discussion. There was, of course, a court case, the so-called Intertanko case, which dealt with precisely this question, whether one directive which related to pollution sanctions on the high seas and elsewhere was in conformity with MARPOL and the Law of the Sea Convention. But the court, unfortunately, did not pronounce on the substance of that matter at all. The court only looked at, well, the claim was that that the directive should be invalidated, and the court said that we cannot invalidate this because of various formal reasons, but so it remains in force. So in that sense, the EU won that battle, but there was never a substantive discussion in the court about whether it actually overstepped the limits of the Law of the Sea Convention and MARPOL, unfortunately. Then finally on the, or two more, one-man show. I think one state show in that sense, in that case. It's not port by port. Port state jurisdiction is not really happening like that. It's more like state. And in the case of EU, for example, it's 27 states show. But there is an element of this in my presentation, yes, that basically port state jurisdiction is utilized as a vehicle for challenging the multilateralism. But of course, you might even say that in some cases it doesn't work, even that if you are a single state, like I mentioned the Belgian example. You need to have a critical mass, unless you are a very big state like the United States, who has been practicing this for many, many years. Or Australia, when it comes to ballast water management, they have their own rules because they are, I mean, certain states have the geographical features that they can exercise this type of jurisdiction, but others just run the risk of being sidelined by shipping, because ports want customers, as we heard, and therefore they have a self-interest in not over-regulating themselves and being overly competitive or aggressive against foreign ships. So this is this is a kind of a natural break on how far they are prepared to go. On technology, finally, I mean, I think this will change a lot, really. This big data revolution that we are seeing is going to change a lot of things. Not only, I mean, it's already happening pretty much in both in IMO and in particular in the EU on this facilitation of ship and shore communication and single window of single notifications and databases that will record. But even more generally with the whole maritime industry, there is so many things that this allows to completely upset. I mean, the whole way that cargoes are fixed, for example. It's a very complicated and old-fashioned system, in fact, involving very many middlemen, whereas it could be a Uber, basically, where cargo owners, if they have the right information, could just click on basically transportation when they see that there is a ship in the region that has space for that sort of cargo, and I'm sure that this type of development will gradually take place also in maritime transport, and it will to some extent revolutionize the way we do the business, and this is just one example. There are probably many more.
Thank you very much. Even though time has progressed way too quickly, I'm ready to take one or two last brief questions. The micro.
Thank you very much. I think the honorable professors are given, there are lectures which is fruitful for us, but there's one question which was raising in my mind, that if a state is not following the regulations of the harbor under the administrative law, what is the binding force to compel the state or any ship of the state which is causing pollution in the environment of the sea, that they should follow the harbor rules to avoid the pollutions? And if any state is not following these laws, then what is the binding force to compel the state to that they should enforce these laws in their boundaries and in their harbors? Thank you very much.
Thank you very much for that enforcement question. Further questions? Is there? Oh, yeah, right. There is the screen question, which I totally forgot because we are very innovative and inventive, and we have a seminar type of thing. I was looking here, and I didn't see that so far. So I can take the screen question. Number one, are newer fuel models such as green ports considered by the shipbuilding industry or other industries? So lucky you can also read them. Do we have a second screen question, or is that? Okay, there comes a second screen question that will be allowed, and then that will be the final one. Would the expansion of another port not suit the EU's interests better from both an environmental and an economic perspective? I'm very sorry, I was waiting for the screen questions. I was looking at the screen and I thought, oh, it's nice, and the environmental law thing, our logo, and I didn't realize that they finally came up. Very many thanks to our technical experts who made that possible. Great solution, great outcome. Thank you. And the floor is now yours. Maybe you start, Professor Ringbohm, and then the final last words for Mrs. Reiling.
Well, I think the first question was relatively directly related to you.
Enforcement, yeah.
So I can maybe try to answer this one. Yes, and I think this is also, in fact, you touched upon it, and I think the answer is clearly yes. There are a number of various types of initiatives that come from grassroots. Some of them come from port sides, but there are also now, for the first time really, we see when it comes to ship emissions in particular and greenhouse gas emissions in particular, we see sort of grassroots initiatives coming also from the ship owner's side. They want to have rules, or they want to have systems in place where they can sort of indicate their environmental footprint, their performance, to show to their customers all this. When the official channels, the lawmakers haven't been able to produce much in the terms of reducing greenhouse gas emissions from ships yet. And this, I think, is a very, very healthy development. And ports have a number of others. They have been, for example, when it comes to air emissions from the sulfur in fuel requirements, there have been gradations of port fees, etc. So I think this is a development that clearly takes place, and it's a very positive and healthy development.
Thank you very much. Katharina Reiling.
I'm not sure if I got the question. It's concerned to enforcement, but enforcement against states or...
Yes, enforcement by the international administrative law on any state or any vessel of any state is causing the pollution in the sea. Might be leakage of the oil. That is hindrance for the fishes and also for the green areas of that state. But if any state is violating these rules, what is the binding force or penal action can be taken against that state?
Maybe I just briefly kind of a international law perspective to this. It is the case currently in shipping when it comes to pollution that all this jurisdiction of ports that they are in the form of rights rather than obligations. The obligations are on the flag states to ensure that their ships don't pollute, but for port states it's about right to make sure that other ships don't pollute, and there is not really a violation of an international. There are certain obligations in MARPOL Convention which says that you need to provide efficient sanctions if somebody violates the rules, but that part of the regime is much less developed more generally in international law. That, for example, in fisheries where this port state jurisdiction has been taken as a duty. But in this part of the world we have then EU that have come with specific directives to rectify that whole and basically require states to enforce through various means. I mean, administrative provisions, criminal law even, and you have, but they only cover the European ports.
Thank you.
Yes, so the EU can foster the enforcement, but that's an exception.
I think the last question, the expansion of another port, would also be something that Professor Heudonk would love to say something to that. I find it a very interesting question, but of course competition comes into mind. If Hamburg would get, now more containers, I think many people in Hamburg would be happy because that means more business. Maybe environmentalists would be very unhappy. But I think it's a very interesting idea if we do not only look at the economic interests of single nation states, but of the European Union as a whole. That might be a very idealistic view, though, but maybe an idealistic view is not the worst thing to conclude a panel. Many thanks to our two, respectively 3 panelists. I think that was a very exciting and a very thought-provoking opening. Now you deserve to relax a bit, and then you deserve also to be nourished not only by intellectual food but also by real food that will be provided at tonight's reception at 8 o'clock. And you find in the program directions how to get there. Of course, you're very free to take a taxi, to take a cab, but it's very easy also to use public transportation. That's also environmental friendly. Therefore, we do that, and we have another reason that we did not provide a bus transport or something from here, because we're not sure whether you like to refresh before you go to the reception in the hotel or something like that. You are free to do so. You got 1 hour. It's, I think, easy to reach the spot. Looking forward to see you there. And so far, thank you very much for that wonderful start of our conference. Thanks a lot. Thank you very much. Thank you. Many thanks for your presentation. Thank you.